Lordship leave to file a mandamus appeal again with the server copy of the order,
When was the order passed?
8th of September. And server
granted.
copy applied on 15th of September.
Original side. That original side is my lord, may I be allowed to mention file this with the server copy, order passed on 13th of September, my lord. And my lord, there is a urgent meeting is to be held on 13th of AGM was called on 23rd of this September.
Yes.
So urgent listing of this matter, my lord.
It will be listed tomorrow if the papers are available. Serve on the other side.
How like this?
With your lordship kind indulgence, may I permitted to mention on application for my lord appellate side. I'm grateful.
Yes, sir, item number 1.
My lord,
The writ petitioner respondent, my lord.
my lord, praying for a short passover, my lord.
For
My lord, on behalf of Mr. Hon'ble Banerjee, my lord. My lord, I am
Appellant.
appellant, my lord.
Number 2.
I am for the appellant, my lord, not this week,
why?
because AVTV of service it's not completed, my lord.
You were the writ petitioner.
I am the writ
Huh?
petitioner.
Abe dao, later.
Relating to Panchayat election. Page number 18, my lord. Page number 18. Representation to prescribe authority. Annexure D.
প্রশ্ন হচ্ছে তিনি যে নিবেদন আমি আবেদনকারী ৪০ বছর
Election
গ্রাম পঞ্চায়েতের অধীনে
election counting will be held in 8
জাস্ট এ মিনিট এবার ত্রিস্তর পঞ্চায়েত আমার স্ত্রী গ্রাম পঞ্চায়েত প্রার্থী এবং ইলেকশন এজেন্ট আমি ওনার ইলেকশন কাউন্টিং এজেন্ট ছিলাম। ইংরাজির তারিখে আমি চাকুলিয়ার 6 হাইট মাদ্রাসার ভোট গণনার দিন দেখা যায় নির্বাচন কমিশন থাকা কর্তব্যরত অফিসার আমাকে মোট 5টি ব্যালট বাতিল দেখানো হয়েছে, কিন্তু কাউন্টিং সময় আরো লক্ষ্য করি যে আরো 30টি ব্যালটে অধিক সিম্বলের আঙুলের ছাপ ও ডেটিং সিম্বল রয়েছে। ভারতবার কাউন্টিং অফিসারকে বলা হয় ব্যালট বাতিল না করে কাউন্টিং করে। তাই আমি আপনার নিকট আসলে আকারে গ্রাম পঞ্চায়েতের না ডেট তো ডেট কি করে বলছি করে আসছি। ও বলেছিল অনেকগুলো ব্যালট বাতিল দেখানো হয়েছে সার্ভিস করে
Very well. You serve and come. affidavit, so not this week.
My lord, GP has been services and election commissioner advocate, I will serve this copy.
We don't know who you will serve, sir,
Have a video, sir. Oh, grateful, my lord.
not this week. Eta lekho, learned advocate for the appellant, oblique writ petitioner, says that service is not complete. Stop. As requested, comma, let this matter stand adjourned and be listed again on Monday. Monday we stop. On that day, on the adjourned date, comma, affidavit of service will be filed in court.
Item number 3,
Short Passover.
4, 5,
Lordship, I appear for the appellant, your lordship. I appear for the appellant, your lordship. Your lordship, there is a section 5 application, your lordship.
My lord, I'm for the KMC, my lord. We may be served a copy, my lord.
I have a
Your
section
basic
5 section 5 application. I can serve right now also, your lordship. If there's a
He
delay of
says he has not received.
it has
Any
just
other
been
party apart from
filed.
KMC?
KMC is the answering respondent, your lordship.
KMC is the only respondent.
Answering respondent, your lordship. Other
That
parties,
is not the
there's a private
question.
respondent.
Question is, are there other parties
Other
on?
parties, seat is there, your lordship.
So therefore, pass over.
item number 6,
I'm for the appellant.
I'm for the private.
State name.
HMC is the concerned respondent. The municipal corporation is the concerned.
item number 7, 8. Second call, item number 1,
Yes.
My lord, praying for or not today, my lord. My lord, Mr. Arindam Banerjee is on legs in another court, my lord.
Not today.
item number 3,
Appellant.
Respondent. Respondent municipality.
ছিল পাস ওভার করো এই তো ইয়েস
Mr. Ranjan Kali is appearing in the case.
who
Mr. Ranjan Kali.
you are there
Give me a short pass. He is coming.
pass over there's nobody here.
There are 15 minutes for
No, we don't function in that manner. 15 minutes, 7.5 minutes. We can't do like that. Thou.
No, this is the affidavit of service.
You are for?
I am for the
Respondent municipality.
yes. Affidavit of service.
You have served the private respondents. There's one.
Already, they have
And
already
that
received.
Pintu Rai.
Oh, I have.
No, Tapu is the councillor.
Your private respondent, page number 15. They have already received.
They have already received.
As per internet tag report.
Let us see.
Item delivered. Into delivered হয়েছে।
হ্যাঁ
Delivery হয়েছে।
আচ্ছা তাহলে ঠিক আছে অর্ডারটা দেখি Pintura is your brother.
Yes,
Pintura is your brother.
Yes. Earlier at page 79, 2010, 2020.
my lord, in view of the order passed in the first writ petition, the municipality proceeded in the proceeding, my lord.
They are saying, sir, that the direction was on the executive engineer. Why did the
Chairman.
board of chairman conduct the inspection? Why did
Lord,
the board of
under section 218, my lord, board of councillors will take steps, my lord. And at that point of time, there was no board of councillors because administrator is, my lord, running the function of the municipality. After election, my lord, board of councillor came into the force, my lord, and they have initiated the proceeding. My lord, this is the copy of the proceeding, my lord. Everything has been done in accordance with law.
learned judge has recorded that?
Yes, sir.
Recorded that. Yes, Mr. Pathak, what is your grievance? What is your grievance?
Even the main, my lord, chief executive engineer, direction was given executive engineer. But report was filed chairman.
This is your grievance.
Main report.
No other grievance.
Sir, and another, my brother start this building without any permission of the sanction.
Without any, take the microphone, take the microphone.
Without any sanction plan.
Under a central project, this was done by the construction was done by the municipality itself. There are standard plans. You are probably not aware. Even under the Indira Gandhi Yojana, Pradhan Mantri,
House for all.
yeah. These are standard plans. No separate plans are sanctioned. And we are absolutely clear in our mind that it is the Board of Councillors under 218 of the 93 Act, which is the competent authority. So what has been done in accordance with law. Anything more?
No.
Let us dispose of. Esho. The dispute. Now, this appeal is directed against a judgment and order dated June 12, 2023, whereby The appellant's writ petition, being WPA 28684 of 2022, was dismissed by a learned single judge of this court. Paragraph. The appellant approached the learned single judge with the complaint that now, in an earlier round of litigation, comma, the appellant had approached a learned single judge of this court by filing WPA 7032 of 2020, comma, complaining that his brother, comma, the private respondent, comma, has constructed a building on land adjacent to the appellant's land without leaving adequate open space on the eastern portion of the property, comma, which is in violation of the concerned municipal building rules, capital A municipal building rules. Stop. His grievance was that his complaint lodged with the chairman, comma, Panihati municipality, was not being considered. Stop. It was submitted on behalf of the municipality that pursuant to the complaint lodged, comma, local inspection was conducted and it was found that the impugned construction was made according to the relevant municipal building rules.
Under the scheme, my lord.
Under the HFA project, which is a central government scheme. HFA, huh? What is HFA?
My lord, house for all.
Oh, house for all. Bracket house for all the. Yeah. Take a Stop. Learned advocate for the writ petitioner submitted before the learned single judge that the inquiry/inspection should have been made in his presence so that he could have apprised the municipality of the illegalities in the concerned construction. Stop. Paragraph. The learned judge disposed of that writ petition with the following observations and directions. Page 81. '81, '82. Next. Pursuant to the said order, comma, the what did the chairman do?
My lord, kindly see, I have handed over. My lord, on 26th of February, my lord, inspection notice was served.
Served inspection notice issued by whom?
Inspection notice, executive officer.
Next. Pursuant to the aforesaid order, comma, the municipality issued inspection notice. Now, the municipality, through its board of councillors, passed an order dated July 4. Now, passed an order which was communicated by the chairman of the municipality to the parties on July 4, 2022. Stop. The order was to the effect that after holding inspection and hearing both the parties, comma, it was found that the impugned construction was neither illegal nor unauthorized and not in violation of any relevant building rules. Stop. It is this order that was challenged by the appellant before the learned single judge in the present round of litigation. July 4, 2022, na? Paragraph. The learned judge, now, the primary complaint of the writ petitioner before the learned judge was that although the earlier order of this court passed in WPA 7032 of 2020 directed the executive engineer of the municipality to cause inspection and give hearing to all parties and pass a reasoned order, comma. The same was done by the chairman and or the board of councillors. Stop. This was not in consonance with the earlier order of this court. So it was further submitted that, paragraph Krida, it was further submitted that no notice of spot inspection was issued and no opportunity of hearing was granted. Paragraph. Learned advocate for the private respondent denied the aforesaid allegations. Stop. He submitted that notice of spot inspection was issued to both the writ petitioner and the private respondent who were represented at the time of inspection. Stop. Hearing was also granted to both the parties, and only thereafter the order was passed by the board of councillors.
No
Paragraph.
notice was received by my client. No notice was received by my client.
Yes, that we have recorded. We are saying private respondent denied that. Next. Learned advocate for the municipality produced documents before the learned judge demonstrating that notice of spot inspection was issued upon to both the parties. Stop. Notice of further spot inspection was also issued. Stop. The notices were received by the parties and they were duly represented at the time of spot inspection and at the time of hearing. Stop. Having considered the paragraph, having considered the inspection report, comma, the board of councillors came to the conclusion that there is no unauthorized construction. Stop. There is sufficient open space between the two premises. Stop. Paragraph. The learned judge came to the conclusion that the board of councillors acted in a reasonable manner in deciding the objection filed by the writ petitioner. Stop. The learned judge also observed that under the relevant law, comma, the board of councillors is the appropriate authority to take a decision in the matter. Stop. The learned judge disposed of. Now, after observing that the writ petitioner's allegation of unauthorized construction on the part of the private respondent remains unsubstantiated, comma, the learned judge disposed of the writ petition by holding that if either of the parties are aggrieved by the order of the Board of Councillors, comma, it will be open to them to approach if either of the parties is aggrieved, or not, it will be open to him to approach the competent civil court for declaration of his civil rights in respect of the property in question. Paragraph being aggrieved, comma, the writ petitioner has come up by way of this appeal. Paragraph we have heard learned counsel for the appellant oblique writ petitioner and learned counsel for the respondent municipality. Stop. From the affidavit of service filed in court, it appears that the private respondent has been served, but he is not represented. Paragraph. The primary grievance of the appellant is that the Board of Councillors could not have taken upon itself to decide the representation oblique objection of the appellant, since in the earlier round of litigation, comma, a learned judge of this court had directed the executive engineer to take a decision in the matter after local inspection and after local inspection and after hearing the parties. We do not see any merit in this contention of the appellant. Stop. Under section 218 of the West Bengal Municipal Act, 1993, it is the Board of Councillors which is the competent authority to decide whether or not a particular construction is unauthorized. Stop. Although the learned single judge in the earlier round of litigation had directed the executive engineer to undertake the exercise, comma, we are of the view that no illegality or injustice has been caused by the Board of Councillors deciding the objection of the appellant. Stop. Paragraph. The appellant further says that he did not receive notice of local inspection. Stop. Learned advocate for the municipality has produced a bunch of documents from its records.
Page 9.
Which?
9. The wife of the appellant has been received on the right hand side.
Which belies such contention. Stop. Let the bunch of documents be kept with the records. Paragraph. We therefore find that the competent authority, comma, after observing the principles of natural justice, comma, after holding requisite local inspection, comma, has come to the conclusion that there is no unauthorized construction on the part of the private respondent. Stop. The learned single judge held that there is nothing wrong or illegal with the order of the Board of Councillors. Stop. We agree with the learned single judge. Stop. We are also of the opinion that there is no infirmity. Either we are of the opinion also, either in the order of the Board of Councillors, which was impugned before the learned single judge, or in the order, which is order of the learned single judge, which is assailed before us in this appeal. paragraph, the appeal and the connected application accordingly fail and are dismissed. Stop. There will be no order as to costs. Affidavits not having been invited, the allegations in this affidavit of service to bolei diyechi okhane je from the affidavit of service filed in court.
Item number 4.
Children, the usual order.
Item number 5.
Your Lordship. Your Lordship, I appear for the applicant. Your Lordship, this there's a Section 5 application, Your Lordship. It has been filed only on this Monday, Your Lordship. So
Have
it
you
has not-
served?
No, I have not served. That is with the
Serve. How much delay?
229 days, Your Lordship. 229 days.
Serve.
I'll serve and then come back, Your Lordship. There are two private respondents.
When will you come back? You were the writ petitioner.
Yes, Your Lordship.
Writ petitioner.
10 days, Your Lordship, because two private respondents.
Is there any merit in the appeal?
Yes,
Dekhi na
Your
ekbar order ta dekhi na.
Yeah.
If there is no merit, then why keep it pending?
Your Lordship. Kindly, Your Lordship, kindly looks at the order.
If we find there is something to be said, we'll adjourn it.
The impugned order, Your Lordship. Your Lordship, if I can give a gist of the case. If I can give a gist of the case. A small gist of the case. This is an
Isn't there an appeal from an order of retention? That's right.
Your Lordship.
If you are aggrieved,
Your
you
Lordship.
can go there, they can go before the tribunal.
Yes, we tried to get the hold of the order of retention. We could not. And Your Lordship, on a prima facie basis, what had happened was this is a 100-year-old building. There were only 3 floors in the building: ground floor, first floor, and second floor. On the garb of a reconstruction, they
Is your microphone on, switched on?
Yes, Your Lordship. On the garb of a reconstruction, Your Lordship, they constructed 2 other floors. There cannot be retention of a major deviation, Your Lordship.
Sir, the authority is KMC.
Yes, Your
right?
Lordship.
KMC has allowed the retention.
But we could not we could not get a hold of the order.
We
that-
direct them to give you a copy of the order.
Yes, Your Lordship.
If you are aggrieved, go and
Yes.
file your appeal against it.
Definitely, Your Lordship.
Sir, give him a copy of for his records,
Yes,
give him
I'll
copies
give
of
right now. Lordship.
Section 5 ta allow kore dao. Affidavit of service have you made? No.
No, Your Lordship.
देखो Section 5 টা allow করে দাও দিয়ে লেখো although it appears that all the parties including the private respondents may not have received notice of this appeal, comma, and only learned advocate for corporation, Kolkata Municipal Corporation, within bracket in short KMC, bracket close, appears, comma, in view of the nature of the order that we propose to pass, comma, we do not deem it necessary to defer the disposal of this appeal. Paragraph. The appellant had approached the learned single judge alleging that the private respondent numbers 9 and 10 have made unauthorized construction. Stop. The learned judge now paragraph Kolkata KMC submitted that pursuant to complaint lodged by the writ petitioner oblique appellant, the department lodged an FIR. Stop. Proceedings were initiated under section 400 of the KMC Act, 1980. Stop. Hearing was conducted by the special officer bracketed building, and in compliance, you were naturally not a party in this sense. And in compliance with the order passed by the special officer bracketed building, the persons responsible deposited the necessary retention fees, and the department regularized the D-sketch, capital D, capital S, plan, vide number, internal page 2 of the impugned order. Number ato dated May 11, 2021. Next, the learned judge disposed of the writ petition with the following observations and directions. We internal page 2 theke bracketed portion. Paragraph. Being aggrieved, the writ petitioner has come up by way of this appeal. Paragraph. Learned advocate for the appellant, oblique writ petitioner, says that the building is more than 100-year-old. Stop. Under the garb of making reconstruction, fresh construction of 2 floors have been made. Stop. Such construction could not have been permitted to be retained. Stop. Any order of retention that KMC may have passed is not sustainable in law. Stop. Paragraph. We find that the competent authority, being the KMC, has passed an order allowing retention of the impugned construction. Stop. The court is not in a position to decide whether or not the KMC should have permitted retention of the impugned construction. Stop. If the appellant is aggrieved by the retention order, he has a remedy by way of statutory appeal under the relevant provisions of the KMC Act, 1980. Paragraph. Learned advocate for the appellant says that the appellant does not have a copy of the retention order. Stop. We direct KMC to supply a copy of the retention order to the appellant within a fortnight of receipt of such a request by the competent officer, by the concerned officer in KMC from the appellant or his advocate on record. Stop. Needless to say, comma, the appellant would be free to take such legal steps as he may be advised, comma, before the appropriate forum, comma, in accordance with law. Paragraph, since we have not called for affidavits.
Item number 6.
And for the private respondent, Your Lordship.
And I think she's for the
And
private.
for the private respondent, Your Lordship.
But your lordship kindly turn to my lord.
Yes, the annexures were given to you on the last occasion.
Along with annexures.
মনে আছে কি ব্যাপার তো কিছু মনে পড়ছে না। Oh, that 6 square meter has been demolished. That matter though, no.
No.
An entire floor has been demolished, yet he wants demolition.
Further
It is a
demolition.
100-year-old building, Your Lordship. I had filed a
Madam-
petition saying that further demolition.
Acha, give us 2 minutes. Give us 2 minutes.
Send a team themselves.
May I place my appeal? My lord? Otherwise they may. Because it is nowadays, this is the system has been adopted by.
Our jurisdiction, আমি কথা ভাব। এটাই ঠিক।
Which is the report, Mr. Banerjee?
The first page is the report. madam.
This one. This one.
That has been submitted before the honorable single bench. madam.
Third floor was unauthorized.
But no.
Second floor was.
Second floor, sorry.
Second floor.
Second floor is the বলেছে।
Ground
Second-
first existed, the second floor was unauthorized.
Second floor.
Third story.
Second floor and one
Staircase headroom.
room was prepared. বললাম কোর্টে দিতে বলছে কোর্টকে দিয়েছে
Yes, tell us what more can we do, Mr. Roy?
My lord, the report, one of the first affidavit, report in the form of affidavit, they have submitted before your lordship. But your lordship kindly peruse that affidavit. My lord, what prompted the honorable single judge to pass an order on 8th March 2022? And what was the order? But your lordship kindly peruse. It is a part of that affidavit, my lord. Which number? Annexure R1, page 6.
8th March.
My lord, 8th March. An order was passed by the honorable single bench in these read proceedings.
Which learned judge?
My lord, it has been included in the affidavit in the report in the form of affidavit, which was presented before your lordship.
Yes.
By the Howrah Municipal Corporation.
Yes.
Page 6, annexure R1. May I place, my lord? And then, my lord, this report was placed, though there was a direction to file affidavit, but this report was only placed before the honorable single bench while finally adjudicated the issue.
This was an earlier writ petition.
No. My lord, the order impugned is, my lord, cropped up from this writ petition, wherein, my lord, the 8th March, my lord Justice Shampa Sarkar was pleased to pass an order.
Order impugned was passed in 4139 of 2022.
Yeah, my lord, this is previous writ application.
That is exactly what we are saying.
I'm sorry.
Yes.
Your lordship, my lord, but the report which was filed before your lordship, my lord, speaks about the direction, my lord, on 8th March 2020. Your lordship got it at the top of the report.
Yes.
That's why I am placing this order. The dispute raised in the writ petition cannot be resolved without affidavit. The petitioner submits that G+1 story building has been existing for 100 years and the detention fee for some deviation have been paid to the Howrah Municipal Corporation. Here it after refer to the city corporation. The corporation regularized some portion. Mr. Sheikh, learned advocate appearing on behalf of the respondent number 5, submits that the construction of additional floor over and above the existing structure had been made without any sanction, and as such, the order of this court directing the corporation to proceed against such unauthorized construction must be implemented. Mr. Banerjee, learned advocate, appearing on behalf of the corporation, submits that further inspection of the premises in question would be necessary to ascertain the exact extent of unauthorized construction, the nature and character of the building which existed as per the deed of conveyance and of the petitioner, and also the portion that were detained upon payment of detention charges. Let the affidavit in opposition be filed within 4 weeks from the date reply thereto, liberty to mention an aforesaid period. In the meantime, the corporation shall be at liberty to ensure that no unauthorized construction takes place over and above the existing structure as per the sale deed of the petitioner. Not your lordship, kindly. Any unauthorized structure beyond the said existing structure which was standing on the plot in question when the petitioner purchased the property shall be proceeded with in accordance with law. The corporation shall also make an inspection and prepare a report and include the same in the affidavit in opposition. A clear demarcation of the existing structure with which the petitioner purchased the property, the area which was allotted to be retained, and the area which be unauthorized, but has been subsequently dealt with by the corporation shall be indicated in the report. Now, in the next writ application, this report.
What happened to this writ application?
That writ application, they may say,
That was your writ application, madam. Correct. What happened to that?
Corporation against that they preferred an appeal. Not my lord has they stated that they were not given an opportunity to controvert that report. So my lord remanded the matter to the single bench again.
And then after remand?
That is still pending.
And this is the same report which is before my lord.
This report and my lord, which is now before your lordship, and the report.
Do you have the order disposing of the earlier writ petition? Have you annexed that? Mr. Roy, have you annexed that order?
Other matter, that order has been annexed, but not in this matter, Mother. Perhaps, Mother. Perhaps this has not been mentioned. I have my order with the other proceedings, other appeal which has been remanded back. If your lordship can look into this.
Yes, give it. We got a copy.
Identical disposal.
18th August.
Both 18th August.
18th August is here.
This is also 18th August. Both the writ application was disposed of on the basis of this report. It was at their instance and the same report was considered in both the matters.
In this writ petition, Mr. Roy's client was not a party. Why did we remand?
It was remanded because of the fact that report was not supplied before deciding the issue.
Oh.
And now, my lord, your lordship, my lord,
Yes. Yes, then
my lord, then, my lord, your lordship kindly consider that the order dated 8th March 2022, my lord, there was a specific direction for, my lord, the swearing an affidavit by annexing this report, but that was not done. Now, my lord, what has done, the report was straight away placed before the honorable court, and the issue. My lord, now, my lord, your lordship kindly, prior to that, my lord, I will place, my lord, 2 pages of your lordship's, my lord, the stay application, my lord. Page 70 and, my lord, page 76. But the, my lord, same issue, and it requires demolition. That has been, my lord, observed by the coordinate bench of this honorable court, my lord, the single bench of this honorable court. I'm sorry. But in this, my lord, the read proceedings, my lord, there is a, my lord, the observation, my lord, the last but 1 paragraph of page 70. The municipal authority has to take decision either to proceed with the demolition of the case or otherwise cannot sit idle over the matter. This court therefore direct the municipal commissioner, Howrah Municipal Corporation, to see that the order of demolition is implemented with full force and rigor unless interdirected by any subsequent decision. The entire exercise should be completed within 4 weeks from the date. Then, my lord,
Full rigor means that is the unless any interdiction, that has to be read together. That.
my lord,
Now, otherwise, my lord, they would stand there, take the undertaking, give the undertaking that anything happens, it is my duty to face. If any fatal accident happens, they will have to take the responsibility. Let them give an affidavit, I will go there.
my lord, then, my lord, page 76.
give an undertaking, we'll direct them.
But I'm coming, my lord. But I'm coming.
When
But I'm-
will,
my lord, your
when
lordship-
will you come,
my lord,
Mr.
your
Roy?
lordship kindly bear me, my lord. But
No, you tell me how long will you take? Tell us.
my lord, subject to lordship's convenience, my
No,
lord.
no.
But
Tell
two
us
things- two things-
what is there in this matter. Please understand.
my lord, pardon me, my lord, for troubling your lordship. My lord, your lordship kindly page 76.
We have heard time and again.
My lord,
We have heard.
but your lordship, see, now, my lord, your lordship kindly come to the report. My lord, once. I'm placing the report. My lord, report, my lord, your lordship kindly turn to, my lord, page 2 of the report. Page 2 of the report, my lord. My lord, my lord, according to their, my lord, paragraph 4. The roof of the second floor and staircase headroom has been mostly demolished on such and such date. At present, further proceeding for demolition of left portion is not possible, and because the structure which may cause collapse of the existing old building, but it is stated unhesitantly that second floor has been covered into full inhabitable condition. But this line, but how it has become inhabitable after, my lord, the demolition of the entire structure? According to, my lord, the municipal corporation, that it has been demolished, but they have said that it became inhabitable.
Inhabitable, what does that mean?
Habitable.
No, inhabitable.
Inhabitable means, my lord, the
What does-
synonym is habitable.
Inhabitable means habitable.
My lord, subject to lordship sanction. My lord.
Well,
I pour in English.
I am even poorer. I am even poorer. Let's call for the dictionary. Yes? আনতে বলো তো dictionary. আরে dictionary চাইছি order নিতে এলো. Do you have a cell phone with you? You can Google inhabitable. Google inhabitable. Well, inhabitable means habitable.
I am poor in this.
Inhabitable is something which is not habitable, Mr. Roy.
My lord, my lord.
দাও।
But I may be poor in handling, but it appears like this, my lord.
তাহলে ভুল বলে লিখেছে ওরা। That I will get it corrected. Inhabitation, inhabitable, না?
এই ডিকশনারি আনো তো দাও। Well, if you are correct, really, I learned something today. But
I try.
let me doubly check.
Written as Basjogyo, but if that it be so, I have to take instructions. I think the engineer who has
It's inhabitable, inhabitable.
has prepared the report, he is very strong in English.
কি বসে আছো কেন তোমরা?
Direct একটা
হ্যাঁ।
dictionary নিয়ে আসতে হবে। Habitable, inhabitable.
তাই তো বলছে বাবা, তো আমি তাহলে ভুল জানতাম। He is right.
I think my engineer is very strong in English.
Possibly, because what he meant was it is
Yeah,
not
it was not
habitable. Not habitable, because
Not habitable.
he says that the roof of the second floor has been demolished. Now, if the roof of the second floor has been demolished, Mr. Roy, it cannot be habitable or inhabitable.
My lord, your lordship, kindly don't take me amiss.
Yes.
But this is the art of keeping hand in glove with the wrongdoer. And it has turned like this. But this is my case. But my lord, I will
They are wanting to demolish everything. Just they need one undertaking.
Yes, only one undertaking, my lord, short, very
My
short,
lord, my lord,
within 3 lines.
my lord,
Let them take
my
the,
lord,
let
other
them
day
take the
you
risk.
observe
Let them take the risk.
competent officer of the Howrah Municipal Corporation has decided that it cannot be demolished further. But I will place before your lordship what was taken into consideration to come to this.
Better is that they should give an undertaking. We will go there and do it.
Another thing, you may engage laborers
No. But
Yes.
and cost will be recovered.
Corporation.
We will merrily do it.
Once, but my oration is not like the Englishman. But my subject, your lordship, kindly have a patience. But your lordship, kindly come to page 4 of the report.
এরকম করে বাড়াচ্ছে।
Concluding part of the report.
Undertaking দেবে আমরা ভেঙে দেবো।
They took a report from a private structural engineer and came to the conclusion that it cannot be demolished.
Then you give an undertaking.
Where are those the municipal engineers?
We have wrongly, rightly taken a report.
We are giving you that liberty to demolish.
But that will come later.
And the
That will come
cost
later.
is recovered from municipal.
But that
Yes,
will come
I
They are concluding part. your
will
lordship.
merrily go and demolish, but let them take that risk. Bas, that's all.
I am only
I think that will end the matter.
But
And they will not take that because they will not take the risk. If anything happens, they will have to face.
I will
Bas,
take the
then finish. Let them come with an evidence.
No.
Why then, why drag it on?
Let them
Why
come
drag
with an
it on?
evidence.
Because assuming I will take the risk, but I cannot, apprise the municipal engineers what is right and what is wrong, because they have.
Mr. Roy, municipal corporation says, sorry, we cannot do it. We also have a right to say something.
Sorry, I'm very excited.
Yes. If we do it, the entire building will collapse. Your client says, no, they are hand in glove. That is not correct. The only solution can be, we allow your client to do it at his risk and cost. Or cost even corporation will pay.
I will give.
But prior to that, I would like to place whether municipal corporation has relied upon his own engineer or they have hired the advice or the instruction from a other structural engineer.
Are you referring to this annexure L
No,
at
but
page 4?
I will refer, annexure
It cost
C, page 30. But I refer annexure C, page 30.
Page
30. Of their the annexures, report with annexures.
Page 30.
my lord. My lord, after
That is the
my lord
inspection
annexing the all annexed.
That is the inspection report,
They
404,
have submitted another report,
404.
Yes, this is the report.
but page 30 of that report, annexed C.
Yes, that is sub-assistant engineer.
That is an inspection report as per my lord Justice Sarkar's order, your lordship.
My lord, your lordship, kindly have a look at this report.
After the submission of the final report, this report automatically goes.
And this is,
Let them take a risk, my lord. Let them give the undertaking, we will take go there.
this report has been
My lord,
considered.
They will
cross
not do
file-
so. They will not do so, my
cross
lord.
file again, your lordship.
They will be behind the screens and they will watch what is being done. Everything has been collapsed. That they are very happy.
Please, please, please.
No. You
Cross
are
file.
too much.
Yes. What is clause 5? Tell us.
At present, no further demolition of the second floor is possible,
Yes.
as there exists only structural members. I don't know what is this. Continuation, moreover, this floor becomes fully inhabitable condition. Again, Malad, these observation of stars,
Poor English, like me.
Malad. And then Malad, clause 7, Malad, your lordship, I will look. The terrace roof of the old two-story building has been reconstructed by inserting 4 RCC column from inside without any permission, but existing dimension and character is unaltered. 4 RCC at the 4 corner of the building has been erected, but that's why I referred to the order dated 8th March 2022.
Yes, next. Tell us. Tell us. We'll hear you for the rest of the day. Tell us.
Sorry, Malad, your lordship has.
No, we are not with you. We have expressed our mind, Mr. Roy. We have expressed our mind. But we will not stop you. You can continue.
Your lordship, if this,
The only solution, they are saying, we will not direct them because they are saying we cannot. Only solution, your client takes the risk and responsibility.
my respectful submission, Malad, in this report also, they have not stated that they cannot demolish.
Go and file a suit, witness action, prove. Prove. File a suit.
This is their report. Report has been taken.
We will, yes, their report.
And Malad, your lordship, can you come to Malad, the annexed aim of that report?
Show us whatever you like to show us.
Who is he to say when the
This
assistant
was
engineer
not a
has inspected?
representation to the corporation
he-
saying that do not
he-
take any
who is
more
he to
hammering on
say?
my building.
And why the corporation has relied upon this report, not upon this report of the assistant engineer? 4 RCC structure has been erected inside the building and then said that now if any hammer comes forward and that will demolish everything. But nowhere, in no report they have stated. The further demolition is not possible.
This report, please understand, Shujit Bose, lawyer of Shujit Bose, Sheboti Dotto, she wrote a letter to the corporation annexing a copy of this report. Therefore, this report has been annexed. It is her client who is relying, not corporation.
That's why when I'm saying. But
Corporation has only- Has only recorded, Mr. Roy, that such a letter is, such a report is there. They are relying on it.
Conclusion, Malad, on the basis of this. Malad, but page 30 of the Malad, assistant engineer's report, nowhere has stated that the further demolition is not possible. And Malad, the corporation till 2019, nowhere has stated.
Malad,
ওরা কি আমার ঘর ভাঙিয়েছিল ওদের?
না, না, ওপরটা ভাঙাচ্ছিল যখন ওর লোকটা চেয়েছিল, যে এই রিপোর্টটা এখনো করেছে।
সেটা বলে দাও জোসেফ। আমরা একবার চেষ্টা করছি যদি ওপরটা ফ্লোরটা দিই। বলে দিয়েছে তো, আমরা পারবো না, আমাদের পক্ষে সম্ভব। ওনারা যদি চেষ্টা করেন করতে পারেন।
My lord, other thing, my lord, subject to lordship sanction. Even a good attitude. Page 38, and it said J.
And further, my lord, what type of construction I don't know, only they are objecting.
Yes, but Mr.
Rightly,
Banerjee,
we are in
another,
hand and gloves with them.
no, just consider another from another angle.
My lord.
We have been firing Mr. Roy's client all this time
Well.
for taking an unreasonable stand. But what if Mr. Roy's client says, this is not concerning you, this is concerning your client, that when you made this unauthorized construction,
It is wrong.
you took a risk that at the time of demolition of this, if the court orders, the entire building may
Yes, that
collapse.
is also a fact.
Why your client took that risk? So why shouldn't we today direct corporation, come what may, go and demolish? If the building collapses, it will collapse.
Already demolished the second floor.
No, not the entirety. They say so.
And there are pictures annexed. to your
No,
motion.
no pictures will persuade us, Ms. Dotto.
Staircase has been entirely demolished.
Corporation says further demolition requires to be done, but cannot be done.
It does need to be collapsed, demolished.
Whatever it is. Fact is, complete demolition has not been done.
It might not, there is a.
However, whatever percentage remains. We are not concerned.
The client had taken a risk of constructing, they have suffered it, your lordship. They have already, they had made the entire.
Let
floor
them suffer. Let the unauthorized portion go. Whatever happens to the building will happen.
Is not there anymore, your lordship.
That is not what the corporation says.
No. There is another.
There is.
But still, problem is this, my lord, we will go there, and if it collapses, it will be very trouble to us. The same case like Mr. Basu's client. Mr. Basu's client also same thing happened, man.
They had. My lord, I will say, may I be permitted to say something, your lordship? Now the difficulty which my client will actually face today, if the entire building is collapsed, it is a plot of Del Katha. They will not get.
So
any
you have
sanction.
taken the risk to raise
My
the
lord, I have
construction.
suffered the loss as well.
No,
your
no, no.
lordship. Kindly
Why
consider,
you
your
have
lordship.
why you
I
have
made a mistake. I paid the penalty, your lordship.
You
The same thing happened, my lord, regarding that Mr. Basu's client also. Same thing.
And I
They
was-
have made that structures,
May I-
and my lord has passed an order that the corporation will now decide what to do in that case. Well, I will come with that order now. Same thing, yes, exactly same thing. We have told it is very difficult for us to, because it will collapse. Then my lord had directed us that we will now finally think what to do.
You have raised the unauthorized construction at your own peril.
My lord, I
The legal-
bow down to your
legal term,
lordship. I
you
bow
don't
down to your
believe.
lordship. But difficulty, your lordship. If they have demolished it,
So go for a settlement.
nothing further can be done with that
For a
portion, your
settlement.
lordship. I cannot neither make anything or demolish anything. It will remain as it is, your lordship. It being there or not being there is the same thing, your lordship.
why should it remain at all, Ms. Dotto?
And another is,
If it is unauthorized,
it is also a fact. It is a 100
why
year
should it
building.
remain at all?
It also causes us very difficult.
No, these are reckless people who take law into their own hand,
They already had a building, they thought of making another floor. When they were making the. another floor-
uneducated, illiterate.
No.
No.
When
We
they were
can-
making
please
the floor, your
Consider,
lordship.
consider our position. We cannot make a precedent. Everybody will come and say.
My lord, the difficulty, your lordship, I had submitted an as-made, as it was then prevailing in Howrah Corporation, your lordship. I had submitted an as-made plan also, your lordship. In spite of that, your lordship. it
And
was-
another thing happened, my lord, that is a 100 years building. Also. That is also causing us very difficult.
appellant, we have to demolish the structure. If any- Mr. Banerjee, when you go and demolish a building under court order, who bears the cost?
No, no.
The wrong.
Wrongdoer,
The wrongdoer bears the cost.
they do bear the cost. Because they required to, wrongdoer means they required to demolish themselves. That is
So
our self-demolition
what
notice.
What we will do, we will briefly record the facts. And we will say that HMC says to the extent possible, it has demolished. It cannot take the risk of further demolition because
our
the
stand.
entire building will collapse. Appellant says HMC is hand in glove with the private respondent. It is possible to remove the unauthorized construction without affecting the
And one thing, only one
authorized
thing.
portion.
Side neighbors also will be affected.
He is the neighbor.
We will grant liberty to the appellant. Appellant will be at liberty at his risk and at the cost of the private respondent to remove the unauthorized
My lord,
construction.
we are very, we will be very satisfied, my lord. Appellant will be.
Mr. Roy, we are not going to direct the corporation. We have made that clear.
As a public authority, we cannot.
Only one thing.
And because they,
If you don't want the liberty, we will not give you the liberty also.
And amenities which are there with the corporation, it cannot be the private party.
yes, now.
And the expert. No, no.
That's why it is the intent of the legislation also. If the private fails, then corporation will demolish and realize the cost from there.
Mr. Roy, we are not going to repeat. We are not going to repeat. We have because
It is very difficult for us.
enough is enough. Yes.
He is not willing to.
Yes, yes.
Yes.
Grateful man.
We have visualized enough from 11:15. We have been visualizing. Cholo, cholo, cholo.
But Malad, corporation has the Malad the expertise to Malad demolish. Malad.
They say they don't. How?
I cannot.
I don't understand.
They will do, but you have to take the
Undertaking, only.
Give the undertaking. They'll do it.
That undertaking.
Give the undertaking.
Not only that, but
You don't have to spend a penny. You have to do nothing. File an undertaking before us.
Yes.
But to that effect,
Think about it. We are going for a walk. Think about it.
Malad, your lordship then Malad adjourn this matter.
No.
But how Malad I can act?
এই জসাকে উঠতে দিন কথা বলতে
That, he is out of residence.
Come back at 2 o'clock. Come back at 2 o'clock. Mr. Royce, we have spent close to 50 minutes on this. We don't want to keep it for another day. We'll dispose of today.
I have disclosed my.
Yes. You take, we'll direct corporation subject to that.
Your Lordship,
Undertaking to the effect that if the other portions collapse, causing loss of life or property or injury, then he will be responsible because it is at his insistence this is being done.
My lord, my lord.
Your Lordship, kindly considers my submission as well, Your Lordship.
Sorry?
My submission, Your Lordship, if the entire building collapses, chances of which are very high, Your Lordship.
You have taken the risk.
And it will be at his risk. His risk. He will compensate you. Entire consequences will have to be faced by him. Responsibility have to be taken by him. You explain to him. In all probability, he will not agree, but explain to him. Yes.
Because he has made one of the ground floor, as they are saying, the dilapidated structure, that they have strengthened by
Mr.
raising pillars in four corner, moving the old room.
We will provide you police assistance also. Don't worry. Okay, go. Remove. Come, we are ready.
Daku.
Can it be?
And the corporation will his best equipment for the purpose of this.
They will use the best equipment at your risk.
I have to.
Item number 7.
No, only one thing, can it be taken up tomorrow?
No.
Total waste of time then today.
Item number 7.
I'm for the appellant. I'm led by Mr. Kolol Bas. I want to start the matter. Look, firstly, supplementary affidavit.
Take the microphone.
Effective because my lord, neither any order copy has been annexed in the memo of appeal nor in the stay application, my lord.
It's supplementary. She's right. She's right. That is why, my lord, supplementary affidavit I file. Oh, that's a copy. Page number 152.
Impugned order is dated 11th August 2017.
Yes, my lord.
Why it is annexed to our memo? It is annexed. Why do you say it is not annexed?
My lord, in the can application not annexed, my lord.
And forget, to the memo it is.
It has not been annexed, my lord, which they have served upon me, my lord.
No, the memo appeal I served, they served.
No, there is no defect. Let us see. What is this supplementary?
Supplementary
Supplementary.
But it was assurance that no order copy has been added. That's why, my lord, supplementary affidavit, my lord.
Can you?
To supplementary have annexed the impugned order.
Yes, my lord.
Why? It is annexed to the memorandum of appeal.
In the
Take it back.
Overthinking is always dangerous.
Dangerous.
I wrongly mentioned the order.
Take it back. Not necessary.
Advertisement.
Let us go through the order. Give us a few minutes.
SDOর কাছ থেকে পাওয়া RTO করে
11th August. তোমার মেমোরেন্ডাম
অ্যাডভার্টাইজমেন্ট
এটা
আর এসডিওর অর্ডারটা কোথায়?
SDO
R3 রিপোর্ট অফ দ্য
Yes, what about service?
সার্ভিস সার্ভিস করেছে সবাই,
হ্যাঁ এফিডেভিট অফ সার্ভিস
সবাই পেয়েছে?
You are for
I am for the private respondents.
private respondent.
স্টেট ইজ নট হিয়ার। স্টেট ও ও আপনি আছেন? ও বাবা, রাজস্বী বাস।
State's presence is necessary.
No, if your lordship decides, my lord, I responded to the advertisement, my lord, I was selected as an Asha Korbi. Now SDO first round litigation, my lord, the honorable court single bench, my lord, directed, my lord, the SDO to consider. The SDO, my lord, passed an order which stands in my favor. Now this order was, my lord, questioned by my learned friend's client. She succeeded, my lord. That is why I came.
Let
here.
us go through the
Only-
order once.
Yes.
अरे तू तो पहले
সকালে কি বলি? SDO order, না SDO order, তাড়াতাড়ি বার করে SDO order।
পিস 50 150
দেখিস নি না করে SDO order আসলে
150 কেজি বললি তো
অনেক করে
150
যেটা যেটা চ্যালেঞ্জ করেছিল চ্যালেঞ্জ করে দেখে বল লিখে দিয়ে আনিস
কোনটা ওটা ফেল দিতে আছে ও স্টেজ বাই ফাইল ডাউনলোড
আমি
করলাম
কেন মামলা নিয়েছিস সকালবেলা এরকম আমরা same 150
You are appearing for Sushma Pramanik
yes ma'am
and
take one
Mr. Bose, the SDO
Page 150.
concluded that weightage should have been accorded to Sushma's, to
SC dominated candidate.
Sushma's
Sushma's.
candidature
Yes, my lord.
as per the provisions laid down in memo number such and such, dated such and such, because it is an SC dominated area. This was challenged,
This
My lord, it was not challenged, my lord.
sought
Yes,
to be implemented by. her.
implemented,
and
because in the meantime, you had been appointed.
Yes, my lord, question is, my lord,
My
my
lord.
lord, this writ petition, my lord, was disposed of, possibly subject to correction, my lord, on the day, my lord, when this was no affidavit of virtue, my lord. Now, my lord, this writ petition was heard by her ladyship, my lord, on that date, my lord, based on this report, my lord, because my fault in this proceeding that I did not question the order, my lord, at page 150. The 150, which she sought to implement, my lord, this was never questioned by my.
Correct, correct.
So, my lord, this point I lose, my lord. I do not have any explanation to offer. Now, my lord, this point's absolutely against me. But whether I can persuade your lordship that the term Agradhikar in Bengali at page 152, whether that is mandatory or, my lord, directory in nature. If other points are, my lord, and my lord, if your lordship, my lord, permits.
Mr. Bose, do this, file informal paper book then. Anyway, this is an old matter.
Yes.
Huh? সুবিধা হবে আমাদের হ্যান্ডেল করতে। Please বলো, কিছু বলবে?
Whether interview was taken as per direction of justice.
my lord, as my lord, in terms
See,
of,
my lord, I tell your lordship, my lord,
in terms of my lord, order dated 31st May 2017, my lord, no steps has been taken up by the concerned authorities. Petitioner filed a second writ petition, my lord, being 2017, my lord, and that order, my lord, was heard where, my lord, my private respondents also made party, and in the said order, my lord, the Honorable Justice Samapti Chatterjee was pleased to direct the respondent authorities, my lord, upon after producing the report submitted by the state advocate, my lord, his lordship was pleased to direct to complete the selection process, my lord, selection process in terms of the order, my lord, memo 2013, my lord. Thereafter, my lord, advertisement has been given, my lord, in terms of 2013, my lord, and my lord, in the said advertisement, as it was illegal, my lord, again that has been challenged, my lord. And that order, my lord, kindly see, my lord.
Mr. Bose, where is the 10th October 2013 memo?
My lord, at page, my lord,
it is,
55, my lord. Page 55, my lord. Here also stated that, my lord, SC coming, yes, my lord,
55.
yes, my lord.
This is date of this notification.
This is the 2013, my lord. It is, it will
Yes, yes,
advertised by,
that is- my lord,
net-
55, my lord, that is 10th October.
Where do you get the date? You both agree this is 10th October to 2013.
Lord, that is my instruction. I asked my client to be present today, my lord. She's, my lord, in a different employer, will go on there. For
My lord,
different-
this is admitted, my lord.
But still, my lord, the highest court of the state, give me 1 day time. Let me give take instruction on this only, because date does not appear, my lord, that what your lordship is asking, my lord, that is not, my lord, the
So-
correct answer.
This notification was given after the judgment of Honorable Justice Samapti Chatterjee.
No, my lord.
No.
No,
This was the first notification, my lord.
First notification.
my lord,
For
on the,
recruitment,
on
my
the
lord.
basis whereof, my lord, the entire selection process was, my lord,
This is the advertisement.
yeah, this is the,
The,
now, my
this
lord,
advertisement,
55 and 152.
General caste candidate, you are
No, 152, my lord, if I am correct, my lord, subject to correction, my lord.
what are the qualifications?
This is, my lord, I made an application, my lord, that this was response, my lord, given by, my lord, the SDO Kharagpur, 17/10/2017. And 55, my lord, if your lordship takes pen, my lord, to turn, my lord, 55 and 153, Big Gopti. That is also, my lord, 27/9/2013, that was issued,
You choose.
154.
55 or 153?
150,
153, my
153
lord.
is Big Gopti, in Bengali it is written, same.
Same notification obtained.
And
As
vacancy,
the second writ petition was, third writ petition was filed, that has been annexed in the said.
Yes, it's the same.
Yes, yes, my lord. And in the said notification, my lord, kindly come to after serial number 3, my lord. One paragraph after serial number. May I read, my lord?
Yes.
এছাড়াও আরো জানানো যায় যে এলাকায় জনসংখ্যা গরিষ্ঠ অংশ তপশিলি জাতি বা তপশিলি উপজাতি সম্প্রদায়ের লোক সেই এলাকায় আশাকর্মী নিয়োগের ক্ষেত্রে উক্ত সম্প্রদায়ভুক্ত প্রার্থীদের অগ্রাধিকার দেওয়া হইবে। এছাড়াও গ্রেড 1 বা গ্রেড 2 প্রাপ্ত সহায়ক দলের এসএইচ সেলফ হেল্প গ্রুপ সদস্য প্রশিক্ষিত দায় লিঙ্ক কর্মীদের ক্ষেত্রে বর্ণিত যোগ্যতাবলী সাপেক্ষে অগ্রাধিকার দেওয়া হবে। Here, my lord, the petitioner, my lord, Susoma Pramanik, not only AC candidate, she also a self-help group grade 1 candidate, my lord. And in the order, my lord, SDO, my lord, it has been specified that the post is concerned totally AC dominated, my lord. And if your lordships kindly come to page 127 for a moment, my lord.
Yes.
My lord, sheet allotted of Asha program at Shobong block, name of the GP Gram Panchayat phone number Dashogram, my lord. Here, my lord, kindly see, my lord, that this the question of post, my lord, Dashogram Patna Lodhapoli, my lord. This is, my lord, number of population 1000 and post allotted Asha sheet, my lord, 1 and reserved for SC. Kindly see, my lord.
We are concerned with Dashogram.
Dashogram Patna, my lord. Dashogram is the Gram Panchayat, Patna is the, my lord, area.
Patna, Bihar.
No.
এখানে একটা পাটনা আছে নাকি?
পাটনা আছে, এটা বলছে
Totally AC. And as per, my lord, Asha recruitment rule, my lord, as my learned senior friends client, my lord, illegally appointed, that was challenged and come to this, my lord.
No, what is your context, sir? What is your context? What would
no,
be
my
your
lord, I relied on the advertisement which she relied upon, my lord,
Yes,
that, my lord, page 55,
yes.
আবেদনকারী যে ব্লকে বসবাস করেন সেই বসবাসকারী, মিলাট আই এম কামিং টু দি নেক্সট, এছাড়াও আরো জানানো হইতেছে যে এলাকার জনসংখ্যার গরিষ্ঠ অংশ, গরিষ্ঠ মিন্স মেজরিটি পার্ট, মিলাট, দি তফসিলি জাতি বা তফসিলি উপজাতি সম্প্রদায়ের লোক সেই এলাকায় আশাকর্মী নিয়োগের ক্ষেত্রে উক্ত সম্প্রদায় ভুক্ত প্রার্থীদের, দ্যাট মিনস প্রেফারেন্স। নাও নেক্সট, এছাড়া গ্রেড 1 গ্রেড 2 প্রাপ্ত সহায়ক দলের এসসি সদস্য প্রশিক্ষিত দায়ী লিঙ্ক কর্মীদের কয়ে বর্ণিত যোগ্যতাবলী সাপেক্ষে অগ্রদার। So two different clauses will run concurrently, meaning thereby that if I come within the যোগ্যতাবলী, that means 1, 2, 5, then also I should be given preference. Not only that গরিষ্ঠ অংশ, both concurrently, and which one is to be given preference, my lord, that is for the authority to decide with reasoning. Now, my lord, the part is concerned, I have taken instruction from the advocate on record, my lord, I want to take instruction from the client that if it is specifically reserved for, my lord, SC, then, my lord, no
That is
argument.
what
No, that is what.
Candidate, my lord, my
If that is so, my lord, there is no point in destroying your lordship's time.
Correct.
I only take instruction from that because there is a part.
You take instruction in page 127.
Yes, yes. Then, my lord, I don't want to appear, my lord.
একটা ছোট্ট অর্ডার রেকর্ড করো। This appeal is directed.
My lord, give me a week's time, my lord.
Is directed. You may go. So next Wednesday.
Yes. That was না রাখতে পারলে মামলা ডিসমিস হয়ে যাবে।
কোথায় গেল এই অনলাইন ওটা? এই খুঁজে পাই না এই। This appeal is directed against a judgment and order dated August 11, 2017, whereby the writ petition of the respondent number 1 herein, being WP 18776 bracketed W of 2017, was disposed of by a learned single judge of this court. Paragraph. The matter pertains to appointment in the post of Asha in Doshogram,
Patna, my lord.
Doshogram, Patna.
Patna,
Which district?
Paschim Medinipur. Paschim Medinipur.
In Doshogram, Patna. Doshogram hyphen Patna. Patna, district Paschim কি বললো?
Paschim Medinipur.
Medinipur.
Under the
Stop.
Kharagpur subdivision, my lord.
It appears that the present appellant was appointed in the concerned post. Stop. The appellant is a general category candidate. Stop. Paragraph. The respondent number 1 herein approached a learned judge of this court. Earlier writ petition, where will be?
First writ petition 20223 of 2006.
Order.
Order dated, my lord.
Number 70.
Annexed.
Annex.
Yes, my lord, it has been annexed,
Page
my lord.
number
I am
70.
coming, my lord.
Page number 70 there.
Page number?
70.
70.
70.
Yes, my lord.
কি বললাম? By filing WP 20223 bracketed W of 2016, challenging the appointment of the present appellant in the concerned post of Asha. Stop. The contention of the petitioner in that writ application was that the present appellant did not satisfy the residential qualification and that she did not belong to the scheduled caste for which the post was reserved.
Yes, my lord.
Stop. The learned judge disposed of the writ petition, that writ petition with the following directions. Page 70, দেখো দুরকম আছে, 71 আছে, 73 টা কাটা আছে, 71 টাই correct বোধহয়। Internal page 3 থেকে। Next. Pursuant to such direction, the concerned subdivisional officer held a hearing on May 31, 2017. এই আগের অর্ডারের ডেটটা বলেছিলাম তো, যেটা ডিসপোজ অফ বলিনি, এই যে পেজ 71 যেটা বললাম অর্ডারের ডেট।
My lord, order dated 31st May 2017, my lord. At page
150.
By an order dated, by a judgment and order dated January 11, 2017. তারপরে কি বলেছি? হ্যাঁ। তারপরে next বলেছি pursuant to the said direction 20 May 31, 2017. Stop. Uh, 17 and passed an order, comma, the relevant portion whereof reads as follows. এই impugned orderটার পেজ 2 তে এটা সেট আউট করা আছে, সেখান থেকেই করে দিও। impugned orderটার যেটা মেমোর সঙ্গে আছে তার ইন্টারনাল পেজ 2 তে এই পোর্শনটা সেট আউট করা আছে। আমি জাস্ট লাস্ট প্যারাগ্রাফটা paragraph. The present writ petition was filed by the respondent number 1 herein, relying on the aforesaid order of the subdivisional officer. Stop. The writ petitioner prayed for setting aside of the appointment of the present appellant and for he also prayed for you be appointed
Yes, ma'am.
and to appoint her in the concerned post. Paragraph. By the impugned order, comma, the learned judge set aside the private respondent in the writ petition, bracket appellant hearing, and disposed of the writ petition with the following directions. Impugned order, internal page 4. Paragraph, being aggrieved, the private respondent in the writ petition has come up by way of this appeal. Paragraph, before us, comma, no, learned advocates for the appellant and the respondent oblique writ petitioner have drawn our attention to the notice. The advertisement issued for appointment to the concerned post of Asha, as well as to page 127 of the stay petition. Stop. Learned advocate for the respondent oblique writ petitioner contends that the concerned post was reserved for scheduled caste candidates. Stop. Mr. Bose, comma, learned advocate for the learned advocate for the appellant say in his usual fairness says that he would take instruction on this point. Stop. If it is found that the respondent oblique writ petitioner is correct in saying that the concerned post is reserved for scheduled caste candidates, comma, then the present appellant has no case at all, since she is admittedly a general category candidate.
My lord.
Paragraph, as requested, comma, list the matter once again on সামনের বুধবার করে দাও। এটা হলে তোমার যেটা হলো পরের পেজ থাকতে হবে।
বুধবার সামনে আসো।
Item number 25.
একটু জায়গা দিন, এবারে পরেরটা শুরু হয়ে গেছে।
Yes, Mr. Sen.
Now, my lord, so far, my lord, the other points are concerned with regard to, my lord, the applicable, my lord, the maintainability of the appeal and, my lord, other points. My lord, those points, my lord, I think I have covered on the yesterday, my lord. Now, my lord, for the purpose of, my lord, now, my lord, the main issue that whether, my lord, that Article 243O, really, my lord, it's a, under that, it's a bar, read with that, my lord, the particular section of the, our act, the state act. Now, my lord, to ascertain the same, if your lordship kindly come again, my lord, that particular, my lord, the impugned order and 2 or 3 paragraphs of the writ petition. Because the entire thing, my lord, it depends, because the, my lord, the proceeding started by filing the writ petition. And, my lord, the nature of the proceeding, lordship, my lord, my humble submission, it depends upon, my lord, what I want to invite the court, that this is the list, this is the issue, or these are the issues. And it depends upon my averment, the cause of action, what I have averred in the as cause of action, and, my lord, the coupled with, my lord, the prayers made therein, and culminating to the, my lord, the order passed therein. So these are all, my lord, in a cumulative effect. It, my lord, it comes that, yes, this is the nature of the proceeding. If the nature of the proceedings comes within the purview of Article 243O, read with, my lord, the particular provision of the State Act, then, my lord, my humble submission, my lord, that it is bar under the, my lord, the law and the settled principle. It is not a fact that what a specific order has been passed and whether that order in fact comes within the purview of that, impede that or not. Entire thing, if I do not, my lord, have, I may have determination, but the principle of law and the several judgments of the Honorable Supreme Court, right from 6 judges bench and followed by several judges, my lord, with the passage of time, there is, this is the law. Then, my lord, whether, my lord, I should have restrained myself or not, sitting in writ jurisdiction. Because, my lord, the main provision, both in the, my lord, the Article 2, my lord, the Constitution, as well as in the State Act, my lord, it starts with, my lord, that is, my lord, a non-obstante clause therein. So today's question is not that what is the nature of the order passed. Today's question is that what is the nature of the proceeding. What I invited the court to enter into the said proceedings, what are the issues before the court. It is not a fact that which prayer the court, my lord, selectively issued to, my lord, to give the relief. Now, my lord, kindly come to lordship, my lord, the impugned order at page 164. Lordship, kindly come to page 165. My lord, it is the, my lord, the second page of the order. My lord, at the top, the paragraph it starts, it appears that the electoral data mentioned in the nomination paper has been overwritten. Then specific case of the petitioners is that the figures mentioned in the nomination paper were tampered. Admittedly, the candidate and his proposer both reside within the constituency from where the nomination was sought to be filed. It is the submission of the Panchayat returning officer that, as incorrect data was mentioned in the nomination paper, accordingly, the officer had no other option but to reject the same. It has been submitted that prior to the rejection, opportunity of hearing was given to the petitioner as well as the proposer. None responded at the time of hearing. The petitioner has filed the representation made to the Panchayat returning officer, specifically mentioning that the Panchayat returning officer intimated the candidate and his representative that the nomination paper was okay, and accordingly there was no requirement of either the petitioner or his agent to appear in the hearing. That is their submission or averment. The complaint lodged by the petitioner was duly responded, wherein it was mentioned that the scrutiny of the nomination papers was carried out strictly following the relevant rules and according to the pre-announced schedule. In doing so, wherever any confusion, defect, mismatch arose or noticed, the concerned candidate or his representative were duly informed and consulted. Then the decision was taken, and in doing so, presence of the candidate or his representative had nothing to do with the decision-making process. When the defect of the electoral data of the proposer was noticed and marked, the concerned candidate and his representative was called, but none appeared. When none turned out, decision of rejection was announced in the block out of 586 nomination papers, only 7 were rejected. According to the Panchayat returning officer, had the decision of rejection being intentional, then the figure of rejection would have been higher. The petitioner submits that his rival candidate was elected unopposed on account of the rejection of the nomination paper of the petitioner. The petitioners have filed an application in connection to the writ petition, wherein it has been specifically averred that the nomination paper of the petitioner was tampered, and the tampering caused the cancellation of the nomination of the petitioner number 1. It has been averred that the nomination was tampered with the intention to reject the same so that the rival candidate may be elected unopposed. The petitioner has averred that the part number mentioned in the nomination paper was 33, but a 0 was added after the figure to make it 330. 120 within bracket 184/261 was tampered to make it 124 within bracket 184/262. Now, up to this, Lordship, this is the case of the petitioner. With regard to, my lord, the foundation of his allegation and entire case, my lord, over around, that is the rejection illegally of the nomination paper by the, my lord, the PRO or the block development officer. And these are all averment. No evidence, nothing. These are all averment. Now, Lordship, kindly come to, my lord, the second phase of cause of action. Next para, page 4, internal page 4. This was the first phase of cause of action. This is the second. Complaint was lodged before the police for taking necessary action. Now it starts about the police inaction. First part of the complaint was with regard to the, my lord, the alleged, my lord, illegal rejection of the nomination paper. And the second part is the complaint with regard to police inaction. Now, Lordship, kindly, the petitioner prays for investigation over the issue of tampering of the nomination papers. Now, again, this, my lord, that election matter. Investigation sought for with regard to that, my lord, the tampering of nomination paper. Learned advocate appearing for the state respondents opposed the prayer of the petitioner. It has been submitted that the petitioners were provided opportunity to rectify the defect in the nomination paper. Petitioners failed to avail the said opportunity, and accordingly, the nomination paper of the petitioner number 1 should be rejected. It has been submitted that the election is long over and the result has been declared, and at this stage, the remedy of the petitioner number one is to file an election petition. That is because when the matter was taken up, by that time, with the passage of time, election was over. Now, prayer has been made for filing an opposition. Very important. Prayer has been made for filing an opposition to the writ petition and the connected application filed by petitioners. Learned advocate, then my lord, kindly come to. Next para, my lord, next page, running page 168, the next page of the judgment order. I have heard detailed submissions made on behalf of both the parties. The thumb rule for conducting an election is that the same should be absolutely free and fair. Occasion should not arise that either the contestant or the elector alleges any illegality or unfair practice in the election process. May I pause here for a moment, Lordship? That only on the basis of the writ petition and averment made by the petitioner, and without giving an opportunity of my lord to file an opposition and to make it contestant in regard to that our rules are concerned, my lord, the learned judge, without even applying the procedure, my lord, under section 45 of the Evidence Act. Though I know, my lord, the writ court cannot, because these are all the evidence to be taken out so far expert is concerned, interpolation, overwriting, who has done this. Now, Lordship, kindly come. My lord, to some extent, though not conclusion, but a prima facie observation, that is the best and or the basis of this order. That is the thumb rule for conducting an election is that the same should be absolutely free and fair. Occasion should not arise that either the contestant or the elector alleges any illegality or unfair practice in the election process. In the present case, allegation has been made against the block development officer who is responsible for acting as the Panchayat returning officer for tampering the nomination paper of a prima facie view has been taken, which my humble submission should not have been.
No, this is stated that in the present case,
Allegation has been made against the block development officer who is responsible. My lord, then allegation has been made against the block development officer. It is not stopped here. Lordship, kindly consider one thing, that the next who is responsible for acting as the Panchayat returning officer for tampering the nomination paper, then again for tampering mean allegation. Then admittedly, the nomination paper annexed to the report filed by the said officer appears to be scribbled and overwritten. According to the petitioner, the same was not done by him. On account of tampering, the electoral data of the proposer was altered. A complaint was accordingly filed before the police for taking necessary action. Again, my lord, it is shifted to police in action. The matter was filed with regard to, my lord, some alleged illegality or illegality with regard to the, my lord, the election process and procedure conducted by the, my lord, the officers concerned who are otherwise engaged. Matter was this. With this and another cause of action, that my complaint before the police authority against that particular officer has not been, my lord, heard yet or responded to. Now again, so filed before the police for taking necessary action. The police appears to have addressed the issue in a different manner altogether. The petitioner never alleged that he was obstructed from filing the nomination paper. Petitioner neither alleged that there was any violation at the time of filing nomination. My lord, the police report that was filed exactly correct so far the police authority was concerned. Because at the time of conducting the election, from the starting to the end, till the date of counting, my lord, the role of the police is just to, my lord, help the, my lord, the administrator, as well as the candidates and the public at large, so that a peaceful, my lord, the election can be held. Nothing more. So the police report was there that no such complaint has been lodged against any person with the police station. So how the police can come with regard to interpolation or overwriting? Now, my lord, the police state nomination paper was submitted smoothly. That is correct. Now, my lord, kindly come to the page, internal page 6. The allegation of tampering brought against a responsible officer of the state, if left unattended, then the general public will lose their faith and confidence upon the public servant. My lord, in a writ court, just on the basis of an allegation that yes, it has been done by a public officer, Now, how the read court can come to a prima facie on my lord the satisfaction? Yes, it has been done and so, and this order should be passed. Or should kindly consider this. When that means the moment the read court entertain the same on the basis of that allegation, that means my lord they cross the limit, cross the bar. That is my lord 243(o), read with my lord the statute. That is the my lord thing. It is
You are saying since this was such a factual allegation,
My lord.
factual disputed fact, that writ court could not have found out the reality, what is true. The writ court shouldn't have directed the investigation, but should have left the petitioner to approach the election tribunal,
yes. Yes.
which can go into factual disputes and find out.
And that is why, my lord, kindly consider one thing. My lord, in Kashmir case also, my lord, it has been, my lord, the recorded by your lordship that one of the ground in the, my lord, our Election Act 2003, one of the ground to challenge any election after it is over, one of the ground is, my lord, that the rejection of nomination paper. Rejection, this is a particular ground, my lord, therein. So he can resort it to that ground. My lord, I am showing your lordship, my lord, 2003 Act about.
No, it is his duty to protect.
My lord, duly protected.
No, free and fair election has become one of the basic structure of the constitution. And this officer is entrusted to protect that principle, democratic principle, that free and fair elections should be held. We have to segregate the issue. He was one of the constitutional functionaries.
True, my lord.
Because during pendency of the election, he has become one of the constitutional functionaries.
Yes.
It is his duty to protect the democratic principle.
My lord.
The basic structure is being flouted at the hands of the officer.
My lord, nobody, my
Argue
lord,
on this point.
my lord, his function cannot
It is not
be
the case
denied.
that one party has registered someone to file nomination, somebody put blockade.
My
This
lord,
is not the case. This is a allegation is leveled against one of the constitutional functionaries, and he is not maintaining
no, my
the
lord,
constitutional norms.
my lord, what failed from your lordship, my lord, I have to admit that.
I
One
also
thing-
admit that he should have been given an opportunity.
No.
I do agree.
I'm coming to that later on, lordship. My lord, so far this, my lord, the observation and or
Why your
what finding.
officer is afraid of
No, my lord.
facing the commission? Why?
No, my lord.
Why is
No, my lord,
if he is correct, then there would be nothing, no problem. I think.
my lord,
This is my
somebody, lordship, may I tell? Suppose, my lord, this is, my lord, my duty to place the court as a lawyer, being a, my lord, the officer of the court, my lord, to place the fact and on behalf of my client, my lord, to contest or place his case, as the case may be, either place or contest his case. Now, my lord, somebody, just a mere allegation, if it is made against me, that being an officer of the court, not my client, but being an officer of the court, my duty is to do this. My obligation is to perform this, but I have not done so. An allegation is made against me, and on the basis of that, suppose I have been asked or I am asked to present myself before a commissioner, before an authority. What I should do? Whether I shall accept that mere allegation or I shall present myself to the commission. If I present myself to the commission, the lordship kindly consider one thing, then at least the mere allegation, irrespective of the fact 5%, 10% or 50% is correct or not. But for the time being, I admit something that yes, something has done or I have done something. When my specific case is that I have not done that.
No, okay, I am not,
Lordship, kindly consider one thing, my lord.
one thing
That
I'm considering your
that
contention.
that
I
that
also
show-
agree with you that opportunity of hearing should have been given. That is true, but
election petition a ground touch I know. My lord, kindly consider one thing. My lord, the power, function, obligation of an officer, and that too, my lord, the returning officer. Here he is the Panchayat returning officer. No doubt, my lord, the responsibility heavily cast upon him. Because the entire election process, though not entire, but the part of that covering his area, really, my lord, rest upon him. He is the person, he is the pillar to hold upon it. But the question is that whether a candidate's allegation would be, my lord, taken in that perspective, that instead of, my lord, asking him to recourse to the procedure laid down in the law, because the grounds to page grounds procedure laid down in the law. Procedure laid down in the law.
Section 93 or 94?
Yes.
93
Section
or
93.
yes.
In section 93 is the grounds for declaring election to be void. I'm grateful, your lordship. Now, my lord, kindly come to section 93C, that any nomination has been improperly rejected. So this is the, my lord, the ground mentioned therein, law laid down by the legislature. And my lord, it is, my lord, also, my lord, fortified by the provision of the constitutional provision, Article 243(o). If that is so, then, my lord, is there any, my lord, extra, my lord, the evidence, or, my lord, is there any corroboration of the fact where from prima facie one can come to a conclusion, yes, something has been done by the officer concerned who should not have, or this mischief has been done by him. But for the purpose of conclusion, the commission be, and you should appear before the commission. Because yes, I have whole prima facie, but I am not, this is not the concluding. So humble, my lord, this thing is that what commission would do, my lord? He has to take evidence. Without evidence, without, my lord, calling the person as a witness, somebody is to be called upon as a witness. Evidence are to be adduced by both parties. So if evidences are to be adduced by both parties, if the witnesses are to be called upon to come to a conclusion, to come to a finding, then why not the actual procedure laid down under the law by an election petition, by, my lord, filing a proper procedural method? Why bypassing the same? Another institution is to be formed by the name of a commission. She kindly consider this. He is not a remediless. And when legislature, my lord, in their wisdom, thought fit that this is the appropriate procedure, then why should be bypassed? My humble submission is that he is not the remediless. And when the act has been enacted, my lord, it was naturally, my lord, hovering in their mind also that filing of election petition after the election, that means that for the time being, somebody is debarred from participating and or enjoying the fruits of the election. And these things is, my lord, parliament election, legislature election, and also, my lord, the local body election, including panchayat. So, my lord, the carving out this and matter, my lord, dealing in an exceptional matter, my humble submission, my lord, there is and there was no such exceptional circumstances to give this relief. And my lord, lordship, kindly consider, and my lord, page number, internal page 5, page number 168. Also 169, my lord. 169. 169, first, second, third paragraph. The direction passed hereinafter is only for the purpose of ensuring that the public servant acted in all fairness to maintain the purity in the election process for upholding the principle of democracy. The same is in the aid of election, not contrary thereto. Then, my lord, I think thousands and thousands of election matters are to be entertained by the writ court. Whoever in the fray of the election, out of suppose 5 out of 10, somebody may come and say, yes, the procedure, something is going to be either I think that illegality may be done, or there may be, I presume. Then each and every, my lord, writ applications are to be dealt with. Because it's a case of assumption. Whereas the, yesterday, my lord said that, yes, that the normal presumption is that, presumptive value is that the government officers have done rightly no wrong. Unless contrary is placed or proved. That contrary does not mean that mere allegation that the government officers has done some or my lord committed some mischief. Here, no, my lord, evidence, nothing except averment. And on the basis of averment, my lord, the writ court come and this observation. Respondent at this stage will be an empty formality and the issue will be unnecessarily delayed. And then my lord, kindly come to internal page 7. The concluding portion of the order. Accordingly, the court thinks to fit to direct the commissioner, Howrah Police Compassionate, it should be commissionerate, to inquire the matter under the supervision of Justice Devi Prasad, the formal judge of this court. Commission will be entitled to constitute a team for conducting the inquiry. It will be open for the commission to examine or cause to be examined any person as necessary to address the issue of the tampering of nomination paper of the petitioner number 1.
Yes.
Now, my lord, the last page of the order, running page 171. My lord, the court was conscious when this order was passed or about to pass. The court was conscious that. Sir, please.
What happened?
বসো না, কি আছে? আচ্ছা, ঠিক আছে, বসো না, প্লিজ। অনেক সিনিয়র, বসে দাও। স্যার,
বুঝতে পারলাম।
Not in this matter, he is not in this matter. I am assisting, I have brief with me here, he is asking me to sit there. So as to he would sit here.
Very well, yes.
Now, my lord, kindly, my lord, the learned judge, my lord, she was very much conscious about the thing that if any order is passed, then if it is, my lord, the against the, my lord, the other candidate, then, my lord, he should be implemented as a party now. Lordship, kindly. My lord, the page 171, the last page of the order, my lord, first, second, third complete paragraph. Leave is granted to the learned advocate appearing for the petitioner to implead the returned candidate as party respondent in the instant writ petition and serve copy of the writ petition and the connected application upon the added respondent. What does it mean? It means that let the report of the commission become filed before me. And and on the basis of the report, I may quash or cancel the entire election process. And then the person who would be prejudiced in that matter, so let him be added as a party. The state of interest. তুমি পাশ থেকে কমেন্ট না করে মামলার সময় বলো না, তোমার যা খুশি বলো, আমায় গালাগালও দিও, আমি কিছু বলবো না। এরকম কমেন্ট করো, বাইরে কেন গালাগালি? কমেন্ট করো, এটা তোমার সিনিয়ররা কোনোদিন করেনি এরকম। Now, my lord, kindly consider one thing, that then what I tell all these things, what I submit all these things, because of the fact, the nature of the proceedings, entire, my lord, thing, if I, my lord, assembled in this way, if I assemble in this way, from filing the petition, the averments in the petition, the prayers in the petition, how the judge proceeded with the matter, culminating to the order passed herein, including that my lord, the last but not least is the direction or liberty given to implead the winning candidate as a party, keeping the matter pending, asking the commission to file the report. That means that the final adjudication will be made, eyeing to the entire election process. So it's, my lord, my humble submission, the nature of the, my lord, the proceeding, it is hit by, my lord, Article 243O, read with, my lord, the State Act. Now, my lord, on the next day, my lord, I shall just place, my lord, some judgments right from, my lord, AIR 1952, and, my lord, the other, my lord, with the passage of time, the other judgments on this point.
Lordship, may I, Lordship, may I make a submission, Lordship, one line?
Yes.
Lordship, since Mr. Shen is addressing on this issue, I beseech your Lordship to just direct him or ask him to address on the page 48 and 49.
I shall
That is
address
the this
Mr.
proceedings
Chatterjee,
of nomination.
we cannot ask him to address
Yes,
in any
because-
particular manner. You have a chance of reply.
I will have.
Well, actually,
That is
Yes,
the problem.
yes,
That's
that
why
is
I-
why I
but
took my-
actually you argued first.
Yes.
He is really arguing. So we'll give you a chance to.
on the
Maintainability of the
question of
appeal and all.
maintainability, I will not.
No.
But other point.
এটা ধরো, yes.
Lordship.
Tomorrow, হবে কাল?
I have no difficulty, my lord.
Friday,
Friday,
day after tomorrow.
get
Day.
ইন্টারিম অর্ডার কতদিন আপনি আছেন?
25
25 কবে হচ্ছে? অনেক দেরি আছে।
Day after tomorrow, Mr. Sen,
25 শুক্রবার।
learned AGP, appearing for the appellants, resumes his submission, but does not conclude paragraph as requested, lists the matter once again on September 22, 2023, marked 12:30 p.m. Try to finish next day
I shall.
Grateful, man.
for further hearing.
না, শুক্রবারই করবো। Grateful. শুক্রবারে যখন শেষ হবে না না মামলা যখন শেষ হবে
Yes, what is your instruction?
One of the my instruction is this. Matlab, they are agreeable, but one matlab, the thing they are apprehending that demolition should be done in respect of entire matlab, the unauthorized construction. That should be matlab, the specific.
Yes, whatever the unauthorized portion is, that. And the undertaking will be, you file it then to the effect. No, you have to file a written undertaking.
Yes, matlab.
It will be to the effect that for all consequences, including any financial loss suffered by the private respondent, they will have to be responsible. This is what we had told you. No, don't look at us like that.
Matlab, one thing, matlab,
Either this is acceptable to you or not. There is no discussion on this.
financial loss, matlab, if they say that the accommodation which I have made, 50 point some square feet area, very good inevitable tiled floor, roof, on all these
Nothing
things.
is there, your
And
lordship.
for losing that part, I have to stay in a five-star hotel.
Take photographs, everything.
My lord, I have
If
photographs.
I
They were annexed, your lordship.
that accommodation, I have to stay at a rented house. But that financial loss should I make?
The discussion is opening.
My
That
house, your
financial
lordship,
loss
I
should I make?
You undertake at first, then we will consider. Okay. You have to submit an undertaking before that.
Well, I will submit undertaking subject to lordship sanction. May I submit? Any damage caused for the purpose of demolition in respect of the building which has not been demarcated as unauthorized construction, then I should be held liable.
Yes, that will do.
My ground floor and first floor
That will do.
definitely is there.
Any damage caused to the portion of the building which is not unauthorized, in the process of demolishing the unauthorized structure, you will compensate the private respondent for that. When will you file the undertaking? In the form of affidavit.
1 week.
Yeah, 1 week. 1 week. Issue.
But I'll just, what your lordship observed, but I will write to that effect. But
Yes.
because forwarding, my lord, that,
No. In substance, this is what the undertaking is.
my lord.
I'm led by Mr. Sandeep on behalf of the agency.
What which is
The appellant, now, the Howrah Municipal Corporation says that to the extent demolition of the unauthorized structure is possible, the same has been done. Any further demolition is very likely to result in the entire building collapsing. Stop. Paragraph. The appellant insists that the remaining unauthorized portion can be removed without affecting the authorized portion of the building. Paragraph. The appellant
alleged authorized, your lordship, kindly do.
That's 100 years of building, your lordship.
May I will show from your lordship, I place before your lordship.
Okay.
Kalam, but
We are dictating the order.
no, one thing, your lordship has seen, Kalam 7 of that report, they have stated that 4 RCC pillars have been taken away
Whatever.
from the inside. But that is also unauthorized. That has been depicted.
the appellant says that he is willing to file a written undertaking in the form of affidavit that if in the process of HMC demolishing the remaining portion of the unauthorized construction, any damage is caused to the portion which has not been declared to be unauthorized, then for all such loss and damage, the appellant will compensate the private respondent. Stop paragraph as requested, comma, let this matter stand adjourned for a week and be listed again on blank, Daita Dida, when the said undertaking in the form of affidavit will be filed by the appellant before us.
Sir, may I see
You are
something?
protected.
I am protected. Only on next Tuesday week, madam.
Tuesday?
Week.
Today, what is it? Wednesday. Next week
Tuesday.
you are not available.
Next week, Monday I will not do. This not this Monday, next Monday.
No, we are saying next Wednesday.
Next week.
Next Wednesday, 27th.
Next week.
Your Lordship, one more thing, Your Lordship, when they allege my entire construction to be illegal here, unauthorized, Your Lordship.
We are not saying anything on that.
See the Howrah Municipal Corporation,
Yeah.
read the report and see which part is authorized and unauthorized.
Correct.
Only
But
that
we will
much.
not, we will take the risk that will collapse.
There is already a demolition order
Fine.
that will be implemented.
And if it collapses, then you have.
Collapses, they pay the consequences. My Lord has made it clear. I'm grateful, Your Lordship.
Mr. Roy, warn your client. He's warn your client. Be very careful. This is not a joke.
But I am warning myself.
This is not a joke.
This order I will.
If something happens, your client will be ruined, completely ruined.
This order I will keep it in my frame, my lord. It will be very easy for me to comply with the contempt applications.
Grateful, Your Lordship.
But it is reminding me that Noida demolition incident.
Yes, original side.
My Lord, for paper books on the previous occasion itself. My Lord, I am filing, my Lord, the paper books.
So why as new application?
No, it was, I think the stay applications were disposed of on the previous occasion.
For hearing.
Yes. it's the
File
memo
your
for-
paper books. Agir order ta dao.
Please
Paper
extend-
books.
Please extend the time to file paper books till today, my Lord.
Time to file paper books. Likhcho. Time to file paper books in terms of our order dated August 23, 2023, is extended till today, till date, karo, till date. Stop. Paper books filed in court today be kept with the records. Paragraph, let this separate paper books in the two appeals.
This is the second one is from an order dismissing review. So there'll be a separate slim paper book for that. For paper book in 3 volumes for the first one,
And for the second one, 1 volume.
1 volume,
So separate orders.
separate orders.
It now এক নম্বরে হচ্ছে, হ্যাঁ? Next, list the matter under the heading hearing. When?
Next Wednesday,
Next Wednesday,
next Wednesday, we have it.
27, September 27, 2023. Stop. Next, এটাতেও same হবে? Same order. খালি পেপার বুক করবে ওটা। একটা আছে, আগেরটা 3টে ছিল। হ্যাঁ, পেপার বুক। তাছাড়া সব সেম হবে।
I take it all the parties have been served. We have been served.
Well, I have also been served, the board of work of.
You are Hooghly.
I'm respondent number 1.
Grateful.
Grateful.
Mr. Banerjee, 1 second. Entry করে একটু অর্ডারটা পাল্টে দাও। Ask your advocate on record to file it in the department.
Department.
Entry has to be made in some ledger or something. ওইটা paper book file in court করো না।
Then extend it till tomorrow.
হ্যাঁ
in a
ওটা
still
তাহলে
cases.
এক্সটেন্ডেড টিল ডেট করেছি, এক্সটেন্ডেড টিল কালকের তারিখটা দিয়ে দাও। লেট দ্য পেপার বুকস বি ফাইলড ইন দ্য ডিপার্টমেন্ট।
Obliged, Lordship.
এইটা হ্যাঁ ঠিক আছে।
Deeply obliged.
এক্সটেন্ডেড টিল টুমরো মানে ডেটটা তো।
For the appellant, your lordship, this is a matter. This is a matter where your lordship remembers.
Remembers, but what? Any settlement?
Of the occupier. in the property.
Lordship, on behalf of the private respondent, I am humbly praying for not this week.
Why?
Since my senior is Sumitabo Chakraborty,
Your senior is?
Sumitabo Chakraborty
Because your senior is Mr.
I
Chakraborty.
will tell you,
has
lordship,
not come to court because his father is undergoing a surgery today.
Oh, you want not this week?
Yes, Lordship.
Yes, yes. We cannot object.
Who? Srijit Chakraborty.
No, your lordship, Shumitabo Chakraborty is the advocate and record for the private respondents. He also called me up that he has gone on angioplasty surgery, his father.
Any settlement?
No settlement. We have approached the other side. They have not come for a settlement.
Anyway, on the prayer made, on the prayer made on behalf of the
Private
private
respondent.
respondent or respondents.
Respondent.
One, private respondent, comma. Let this matter stand adjourned and be listed again on Sombare date দিয়ে দাও, September
Sombar,
27.
kindly any date, Lordship. Sombar. Monday, not Lordship. Any day or
Not Monday.
not Monday,
Seeking
Lordship.
for a week sanction.
Oh, then Wednesday.
Grateful, Lordship.
Wednesday.
This is with regard to compliance of 412A circular regarding rehabilitation, which they have not given. Your
We
lordship
remember
remembers?
that. We remember.
Absolutely.
They said they have Mr. Srijit Chakraborty was.
Correct,
here.
correct. Yes, yes.
Yes.
They have said that they have kept a place earmarked and they say that if I win in the suit, they will
Yes.
rehabilitate.
Yes.
But the circular says that bereft of the suit, it is not dependent upon the suit. It says occupier. Admittedly, I'm an occupier. If I'm an occupier,
No, they don't say that it depends on the results of the suit.
no, they have said that. The circular says that they have to rehabilitate.
Naturally, whose suit is it? Whose suit is it?
My suit.
If you lose the suit, have they filed an eviction? No.
No, they have not.
No.
They have not. But admittedly, I'm an occupier. That rehabilitation.
No, no. Your advocate on record is Mr. Niloy Sengupta.
Correct. Yes, yes. Absolutely.
No, he was saying that no second floor, no, I will not take this, I will not.
Fourth floor.
Yeah, fourth floor.
That we have that I have told him that you cannot choose.
Yes.
That you cannot choose. They have to rehabilitate. If there is a rehabilitation earmark space for you, then
Yes.
you have to go by it.
That we will ensure.
Yes, yes. I have said to the advocate, you cannot choose that. If you're an occupier, you have to go by if there has to be a rehabilitation, you should be satisfied with that. That I have pursued him now. Now he's agreeable with me. That won't be a problem before a lordship now.
That is more like one A Banerjee.
Yes.
Wednesday.
Grateful, your lordship. Grateful.
My lord, I am praying for not today and not tomorrow regarding this. Him only
Huh?
because Mr. Alok Kumar Ghosh is arguing one matter. So he is praying for actually not today and tomorrow. Tomorrow he has some difficulty.
We'll do it on Friday,
Lordship.
Friday, my lord. If
Monday.
lordship grant adjournment, not Friday.
Monday,
Monday. Or any other day.
on the prayer meet on behalf of Kolkata Municipal Corporation. Comma, let this matter stand adjourned and be listed again on September, Monday.
Number 5.
Not to proceed with the matter, my lord.
Sorry,
Not to proceed with the matter, my lord.
learned,
Evolution proceeding, my lord, completed.
All are completed.
Executed.
learned advocate for the learned advocate for the appellant says that he has instructions not to proceed with this appeal. Stop. Let the written instructions be kept with the records. Paragraph. APUT such and such is dismissed along with GA such and such. Same point.
সময় দিতে হবে। স্যার ডিপার্টমেন্টে একে ডাকতে ডেকে পাঠাতে হবে।
Item number 8. Nine. 10. 11. 12. 13. 14. 15. 16. 17. 20. 21.
My lord, I am appearing for the private respondent. The petitioner is not my. No, my lord, I am for the private
Pass over,
respondent.
pass over.
22. 23. 26. 27. 28. 29. 30. 31.
Your lordship, I appear for the appellant, your lordship. One revisional application is pending before the court number 19, your lordship, unless that is been decided, your lordship. So I'm praying for 2 weeks time, your lordship, 2 weeks adjournment in this matter.
Appellant, this is a contempt application.
Yes, your lordship, because that issue has been decided by this, because one revisional application has been filed, your lordship, by the other side, your lordship.
For revisional application.
Yes, your lordship. One issue is pending, your lordship.
What are you saying? What revisional? The contempt must be for violation of an order of this court.
Yes, your lordship.
How can there be a revision by this court of its own order?
No, lordship, the other side has filed in this respect, your lordship, where the order has been passed, your lordship, in the earlier rate, your lordship. The
How can there
MAT,
be a
your lordship.
revision we are not following. Go find out.
Yes, your lordship.
Hey, pass over. Chalo.
32. 33.
Your lordship, I appear for the petitioner appellant, your lordship. In item number 33, your lordship, I appear for the appellant. This is the first time contempt is coming, your lordship. Affidavit.
You are Mr. Nikhil Gupta?
Yes, your lordship.
First time?
Yes, your lordship.
No. An order is there.
Oh, there was a call to serve the other side, your lordship. There was an order, your
Yes.
lordship. I'm filing my affidavit of service, your lordship.
Why did you say first time?
Your lordship, I had the instruction earlier. That's
Had the instruction, your name appears in the order.
your lordship.
How? Affidavit to the.
The first time is still the first time.
But as per your lordship direction, my lord, I served the copy of the application to the alleged complainant.
এই ভাই contempt application টা কোথায়? Can 1. এইটা। মুস্তাফিজুর সার্ভিসটা দেবেন আবার একটা কন্টেনার একজন কন্টেনার
একদিন ভিতরে গিয়ে দিয়েছিল ব্লক মেডিকেল অফিসার
সেম লোক ওই মুস্তাফির রহমান হচ্ছে নাম, ও হচ্ছে ব্লক মেডিকেল অফিসার, দুভাবে সার্ভ করেছে তাহলে। এসো, what is the nature of the order? What was the order?
Order, page 20 onwards.
20.
And ordering portion, page 21 bottom. However, the competent authority, page 21 bottom. Competent authority to whom the appellant has made a representation should decide the same one way or the other. Accordingly, we direct the competent authority to whom the appellant has made the representation to dispose of the same by a reason.
You're appearing?
No, Lordship, I am appearing in the item number 27, I missed out.
20?
7.
কি হয়েছে 27? পাস ওভার হয়েছে। ইয়েস, না এমন ভাবে এসে দাঁড়ালো কারণ ডিসমিস হয়ে গেছে ডিফল্ট। From the affidavit of service filed in court today, comma, we see that the alleged contemnor has been served with copy of the contempt petition. Stop. However, nobody appears for the alleged contemnor. Paragraph. It appears that the alleged contemnor has taken court proceedings very casually. Stop. There will be a rule as prayed for. Stop. The rule is made returnable.
Within a 15 days, man.
2 weeks. 2 weeks hence bracketed tarikta diye daw. Paragraph. The petitioner will put in special messenger cost with the department to expedite service of the rule on the alleged contemnor. Stop. Contemnor in course of the week. Stop. Paragraph lists the matter.
Great. Great.
This is the first date, my lord.
First time.
First time, my lord. But practically is that, my lord, when the matter was disposed of, my lord, I prayed before your lordship, there is a multi-story building, some more time may be given. My lord, at that time, my lord could not recognize, it is quite natural. But sometime, otherwise, this is a multi-story building, there is deviations. And we have to calculate the deviations, we have to go there.
This is contempt has not been served as yet on you.
Sir, no, I am actually, I do not want the rule may be issued. So I want the things should be complied with. My department will.
No, Mr. Banerjee, once somebody appears, we don't immediately issue rule. We grant opportunity to file an affidavit explaining why the order has not yet been implemented.
As you lord.
So you accept service since you are appearing. Kindly.
This is the first date, my lord.
Sorry?
My learned friend said this is the first date. Lord, you will kindly come to page 14. First date after how many years?
Page 14.
Page 14. That is the order, my lord, your lordship passed. This court is surprised as to why the HMC has not taken aggressive step to demolish the unauthorized construction for over 20 years. First date. This is the first date. The petitioners and other flat owners on the premises are not only guilty of committing illegality, but have also been enjoying the same for the last 20 years. Petitioners and other flat owners have not taken any step against the promoter till date. They are thus parties to the illegality. But however, my lord, lordship kindly goes to page 15 and your lordship directed my lord give some direction. With regard to regularization of the flat against which I was under allegation, that is one. And the second thing is that the total ground floor,
You were the writ petitioner,
I was the
writ petitioner
Right.
appellant, writ
Yes.
petitioner appellant.
but my lord, so far as the ground floor is concerned, that ground floor has been totally converted to a thoroughly unauthorized construction, for which my your lordship directed that a representation, fresh representation, and they will consider it. Nothing has been done. It remains as it is. My lord, I beseech your lordship's observation. Let them file their return within a period of 1 week.
1 week impossible.
2 weeks, 2 weeks. Knowing them,
Well, let it be 3 weeks, my lord. I have to take instruction.
After
and
2 years,
whatever Sarkar is going on, my lord, that is my
after 20 years,
headache.
well, it is up to your lordship.
And 5 writ petitions has been filed. 5 writ petitions. One by one, this person.
Yes. Therefore, you send me to jail.
this contempt application has been taken out for alleged willful violation of a judgment and order dated June 8, 2023, whereby MAT 808 of 2023 was disposed of along with the connected application. Paragraph. By the aforesaid order, comma, this court had affirmed the learned single judge's order directing removal of unauthorized construction on the ground floor of the building in question. Stop. This court had also expressed its hope that the corporation shall take such steps expeditiously as no unauthorized construction should ordinarily be allowed to stand. Paragraph. Mr. Ali, learned senior advocate appearing for the petitioner says that the unauthorized construction on the ground floor of the building stands as it is.
Yes.
Stop. No steps have been taken by Howrah Municipal Corporation in respect of such construction.
And our representation also not considered. Because
So my instruction may be noted. that
Representation.
We have made an inspection already. Already inspection has been done.
Anyway, you come back. So Mr. Ali further says that the representation made by the petitioner in terms of our aforesaid order has also not yet been considered by the
yes.
Howrah Municipal Corporation.
Right.
Paragraph. Although this is the first listing of this application, comma, we find Mr. Shondipon Banerjee, comma, learned advocate, comma, in court, and in court, stop. He says that he is instructed to take service.
I've given a
accept
copy to him.
Accept service on behalf of the alleged contemnor. Stop. Let a copy you have given.
Yeah, I have already.
Stop. A copy of the contempt petition has been made available to Mr. Banerjee. Stop. Paragraph. Let the alleged contemnor file his affidavit in opposition.
In report, man. I will report, I will file. No problem.
Very well. File
Yes,
file a report in the form of affidavit.
File.
In the form of affidavit. আজকে কত তারিখ? 20.
20th. Today is 20th September.
Yes. 9th October. Yeah. By October 9,
Right.
do you wish to file a reply? Not necessary.
9th October.
Yes.
Bharat
Just
Chhado.
9th October?
9th October, by 9th October. They will file a reply by
9th October হচ্ছে ভারত ছাড়োর দিন। Yes, quit India.
Oh,
Yes.
should we keep it on the
No, it's not real. That is all right. A good day.
10th, 9th October affidavit with advance copy to learned advocate on record for the petitioner.
Yes,
Paragraph lists the matter on October 10.
10. Deeply well. Let it be on the 11th one.
11.
11th.
11 sir, 12.
Then affidavit by 10.
12.
I will file by 9.
My learned colleague is
Grateful,
not-
grateful.
12, my
12.
12. Instead of
12.
11.
12.
You know, she-
I will file by 9, no problem. Mr. Ali will, if it is after vacation, it is already. হ্যাঁ এটা দেখুন না স্যার
10 তারিখ।
আমাকে তো করতে হবে কমপ্লাই
Item number 35.
পুজো তোমারও আছে আমারও আছে না?
Second, my lord. It's first time, my lord.
First time.
Yes, my lord.
Thou.
Case 21 of the order. Contempt application. my lord. Ordering person, page 3, page 27, page 23.
Ordering portion is
Page 23.
23 বলছো
Near page 3.
23. No hearing has been granted. Nothing. No order passed. Esho.
This one missing.
Yes. In course of the week, this contempt application has been taken out alleging willful violation of the judgment and order dated April 24, 2023, whereby this court had disposed of MAT 606 of 2023 along with the connected application. Stop. The relevant portion of the said judgment and order reads as follows. Mark করে দিচ্ছি। Page 23. Paragraph. Learned advocate for the petitioner says that, how did you communicate?
Page annexer P3, page 70, right, later dated 26/4/2030.
70.
70, yes, my lord. Drag report is 75.
You will know learned advocate for the petitioner.
Yes.
Petitioners, একাধিক আছে মনে হয়, দেখে নিও বাবা এগুলো।
Yeah, that the contempt notice was also, sir.
That the said order was duly communicated by learned advocate for the petitioners to the alleged contemnor under cover of a letter dated April 26, 2023. Stop. The alleged contemnor received such letter as would appear from the track report annexed to the contempt petition. Paragraph. Let service of the contempt petition be effected. Why a special messenger? This is not a rule. We are not issuing rule.
Garnet single judge as well as your lordship, the Pradhan never appeared much. Intentionally did this.
Oh. If you can show surveys, if they don't appear, then we'll issue rule. Why spend money now? Bolo? Be reflected on the alleged contemnor and affidavit of service be filed in court on the next date. How long will it take?
1 week.
1 week. Paragraph lists the matter once again on
Otherwise, my lord, again, service report.
2 সপ্তাহ 4 তারিখ October 4th October.
Number 36.
My lord, I am from the petitioner. I am begging for a short passover, my lord.
Who is for the state? Who is for the appellant?
But appellant Mr. Hon'ble Sen.
Oh, sorry.
I am for the.
Sorry, মানে?
তুমি আছো নাকি মামলায়? তাহলে কোর্টকে এভাবে মিসলিড করছো।
First call Passover, Mr. Banerjee, what can be done?
Item number 37. 38.
I am applying on behalf of the private respondent number 7, lordship. I think the municipality is also there.
First call Passover.
9. 40. 41. 42.
I'm for the appeal.
43. 44.
Appearing on behalf of the respondent number 7, other side is not present yet, ma'am.
45. 46.
46. Praying for a short passover now.
47. 48. 49. 50. 51. 52. 53. 54. 55. 56. 57. Second call, item number 9.
Appear to the respondent. Lordship, I am appearing for the appellant in this matter. Sohini Chakravarti is appearing in this matter. Just left the court premises due to her illness. Kindly praying for not today, your lordship.
Not today.
Item number 10.
ছিল ইউজুয়াল অর্ডার কোনো এক্সেপশন কেন করবে ইউজুয়াল 16 সালে এই ম্যাটার
12. 13. 15. 15. 16.
My lord, I am for respondent number 7 to 11. I am praying for a short passover, my lord.
Why?
I have been led by Mr. Banerjee and Mr. Gaffer, and they are like on
You want the appeal to be allowed?
absolutely not.
No? You want the appeal to be dismissed?
Yes.
Then dismissed.
Your Lordship, I'm for the appellant, Your Lordship.
Where were you?
Your Lordship, I was just
Yes.
on my legs, Your Lordship. Your Lordship, affidavit of service has been complied with, Your Lordship.
Affidavit of service has been complied with.
Yes, Your Lordship, there was a line, in the last occasion, there was a direction for affidavit of service, Your Lordship. No, I'm not fine. Your Lordship, this is the affidavit of
Let
service.
us see the order. Let us see the order, madam. আমাদের order. এই কি দিচ্ছ 16 নম্বর হ্যাঁ বীরেন্দ্র কুমার রায় হ্যাঁ ও তাই বলো I see. Affidavit of service. You want what, an adjournment?
No, I want to pass over.
You want to pass over?
Your Lordship,
When were you enrolled, madam? When were you enrolled?
2015.
15? 2015. They wanted a Passover. What to do?
fine.
Should we adjourn it till next Wednesday or pass it over?
Your Lordship.
Next Wednesday. Not today.
Item number 17.
17 Lordship, I am for the private respondent and 18
Yes,
for the appellant.
Mr. Nilanjan Bhattacharya
Bhatt
was.
is addressing the court, Lordship.
Where is he?
Mr. Bhattacharya has completed his argument on the last occasion, Lordship.
Yes.
According the information that we don't have to submit anything else.
Then it was the Jila Parishad. Jila Parishad also has nothing to say.
Nothing to say, Lord.
Then who will speak now?
No, Lord, Mr. Ghosh, Lord,
In
Lord,
Mr. Ghosh will give reply.
reply.
Where is he?
Lord, he is engaged in court number 26, Lord.
Tell us what to do
Then in that event, your Lordship, can you adjourn this matter, Lord?
for the day.
For the time, next 2 days, Lord, he is not available, Lord. Monday, your Lordship, can you fix it Monday, Lord?
Dekho. Learned counsel for the respondent number 6. Respondent number 6.
Yes, private respondent.
For the private respondent, Shonali Rapilta. In MAT 42. Concludes his submission. Paragraph on the request made on behalf of the appellant in MAT 42 of 2023. Comma, let this matter be listed again on Monday, 25th of September 25, 2023, comma, to enable Mr. Ghosh, comma, learned advocate for the appellant to make his submission in reply.
Item number 20.
Item number 14, I was conducting it in court number 30.
Which one?
Item number 14, man. The dismiss for deferment, I was conducting it at court.
14 Corona. 14. You are for the appellant?
Yes, ma'am, I am appealing for the.
Take it, not today.
Grateful, I am really grateful.
In this matter, Mr. Biswajit Mukherjee was arguing before your Lordship on the yesterday.
Yes,
But he is on leave and some other court today, just now,
My lord, I have received news.
You are assisting him.
I am assisting him, my lord, it may be.
Now you assist the
day after
court.
two.
You were assisting him. Now you assist the court.
It may be taken up day after tomorrow.
Huh?
Day after tomorrow.
Day after tomorrow. You will not assist today.
No, tomorrow he will not be available.
You are available, Mr. Devnath.
It is, my lord,
Friday,
see-
Friday,
on
Friday.
21,
Your lordship, I am for that.
Yes. Yes, yes, we remember. Salt Lake and Howrah.
Salt Lake and Howrah.
Yes.
I am led by Mr. Siddhartha Banerjee.
Lordship, I am led by Mr. Arvindo Banerjee.
Mr.
Arvindo Banerjee.
Mr. Aurobindo Banerjee. Let Mr. Aurobindo Banerjee come. I'll tell him.
So my lord, my senior's instruction is that let them conclude with the locus standi.
Yes, let them conclude.
Your lordship,
You take notes. You take notes for your senior, Mr. Aurobindo Banerjee. Yes.
last occasion, your lordship, I have already submitted regarding the
এই আমি কিছু একটা লিখছিলাম না? হ্যাঁ, লিখছিলাম। ও এর পেছনে লিখছিলাম। Yes.
your lordship, last occasion, I have already.
We are now on the point of locus.
May I? 2010 volume 2 SCC 27 I have placed before your lordship. The judgment of Honorable Justice Amrita Sinha I have placed before your lordship, and the another judgment which was passed by Honorable Justice Devanshu Bosak, just the mirror face in this regard. On that point, locus standi has been maintainable. Honorable Justice said on that judgment. Today I want to submit before your lordship regarding the two very famous case, Deepak Mukherjee's judgment, 2013 volume 5, SCC page 336. First, I want sub. Lordship, may I? May I please? Your lordship, the judgment of kindly come, your lordship. Paragraph 7 first, your lordship. Here, paragraph 7, Priyanka state judgment has already been distinguished by the Honorable Supreme Court. Now, your lordship, kindly come. Paragraph number 8 first, then 10. May I read, your lordship? 8. What needs to be emphasized is that legal and unauthorized construction of the buildings and other construction not only violate the municipal law and the concept of planned development of the particular area, but also affect various fundamental and constitutional rights of other persons, your lordship. The common man feels cheated when he finds that
those making illegal and unauthorized construction are supported by the people entrusted with the duty of preparing and executing master plan, master stroke development plan, stroke zonal plan. The reports of the demolition of Hardman and Jokris belonging to the poor and disadvantaged section of the society frequently appear in the print media, but one seldom gets to read about demolition of illegally and unauthorizedly constructed multi-storied structures raised by the economically affluent people. The failure of the state apparatus to take prompt action to demolish such illegal construction has convicted the citizens that planning laws of enforced by the against poor and all compromise are made by the state machinery when it is required to deal with those who have money power or unholy nexus with the power of corridors. Now, your lordship, kindly come to the paragraph 10. The appellant is an enlightened resident of Kolkata. He succeeded in the convincing of the learned single judge of the Calcutta High Court to order demolition of the unauthorized construction of multi-storied building by the respondent number 7, Messrs. Such and such, respondent number 8, such and such, but could not pursue the division bench to affirm the order of the learned single judge, and this is reason why he has approached this court. Now, your lordship, kindly come to paragraph number 29. May I read, your lordships? It must be remembered that while preparing master stroke zonal plans, the planning authority takes into consideration to prospectus of future development and accordingly provides for basic amenities like water and electricity line, drainage, sewerage, etc. Unauthorized construction of building not only destroy the concept of plan development, which is beneficial to the public, but also places unbearable burden to the basic amenities and facilities provided by the public authorities. At times, construction of such building becomes hazardous for the public and creates traffic congestions. Therefore, it is imperative for the public authorities concerned not only demolish such construction but also impose adequate penalty to the wrongdoers, your lordship. So, in this paragraph, Honorable Supreme Court held to large number of public affected by the unauthorized construction. So, any person has a fundamental right as per the judgment of the Honorable Supreme Court stated in 2010 volume 2 SCC page 27, violates the fundamental right of the public. If any unauthorized construction is raised, its effect to the large number of public. So any person have a right and file the writ of mandamus regarding any unauthorized construction, your lordship. Your lordship.
There are so many unauthorized construction going on. How many you have?
Your lordship, in this regard, what happened may come to the short facts of this case. Two portions is here. One is deviation, which has come to our knowledge when the Honorable Singh.
How many cases you have filed against unauthorized construction? Not only this one,
That
the first one.
this is the first matter, as I.
Who is making who is the person responsible? Who is making the unauthorized construction?
The respondent number 10.
What is his name?
His name is Niruddesh Samanto and
Oh, Niruddesh Samanto.
the private
He must be a good friend of yours.
Sars TN Gupta Private Limited.
He must be a good friend of yours. Only his construction you have.
Another thing is the complaint is regarding the 16 feet road is there. And according to the building rule, near 16 feet road, G+3 must be sanctioned by the KMC. But in this case, G+4 has been sanctioned. Additional sanction plan has been given in favor of the private respondent. If your lordship kindly come to my stay petition and at page 113.
That is the
The complaint is regarding at G+4 storage building in front of 16 feet road. How is
it is not that the respondent number 10 has made a construction without sanction plan.
and your lordship, when the report has one complaint has been made,
Is there or is there not a sanction plan?
additional sanction plan has been granted.
Challenge it. Why are you saying this is an unauthorized construction?
Because your lordship, if your lordship kindly come to the rule.
Mr. Das, so long as a sanction stands,
And deviation has been made, your lordship.
that is a different question. But if the corporation has sanctioned illegally, then you take it up with the corporation.
I have made a complaint, your lordship, but that has not been disposed of by the corporation, your lordship.
We'll direct them to dispose of.
No step has been taken after filing of the complaint at page 113, your lordship. Kindly come to the 113. Your lordship, kindly come page 113 first, the complaint.
What is your representation, copy of representation
At page 114, start from 113.
that has not been disposed of?
Till date, that has been not been considered. And for this reason, I have filed this writ petition. And Honorable Justice Amrita Sinha directs them to file report. When the Kolkata Municipal Corporation file the report,
We will ask you to, your client to appear personally before the hearing.
I'm sorry, my lord.
Your client will be asked to appear personally at the time of hearing.
Yes, my lord, as your lordship.
Your prayer in the writ petition is not for consideration of your representation.
Yes, for construct mandamus for demolition of the fourth floor, your lord.
Correct. Yes,
My lord, sanction plan has been granted. After that, G4 storage building has been.
correct. Madam, all we are doing, we are not passing any order against you. They have made a representation to the corporation. That representation will be disposed of by the corporation after hearing you, after hearing them, after hearing everybody concerned. You are the corporation to dispose of their representation. If you have sanctioned, then say so. Say that your sanction is a valid sanction.
That was already recorded.
Oh, report. Have you annexed that report?
Yes.
Where?
If your lordship kindly come to the report at start from page 118.
No.
Here, when the report has been filed by the Kolkata Municipal Corporation, clearly here it has been stated deviation has been made under Kolkata Municipal Corporation
Maha mushkil.
Act. Deviation
Where is the report?
report is at page 128, my lord. Starts from page 128 of the stay petition, stay application.
Instruction.
They have also annexed in the opposition, Your Lordship.
This is a report dated 13 December 2022.
Yes,
It's captioned instruction.
Demolition proceeding was executed under section 400 or regularized. Aforesaid deviation were regularized.
and deviation has been regularized, Your Lordship.
Yes.
Under KMC Act, deviation cannot be regularized.
Minor deviation can be regularized.
I am showing one provision, Your Lordship.
Tribunal is here.
Your Lordship has already decided from my learned senior friend. I came to know Your Lordship have already decided in a one matter Nirmal Kumar Das, where deviation cannot be regularized under KMC Act, Your Lordship.
No, what we have said that minor deviation can be regularized.
Your Lordship,
If
the
actual
min-
that are
regard-
major
regarding
deviation.
minor deviation, Your Lordship, no such.
Mr. Mukherjee, we know you are not appearing in the matter. If somebody, if a neighbor, let us say, forgetting the question of locus standi, somebody is aggrieved.
Has a locus standi. Neighbor has a locus standi.
No, forgetting, he is not a neighbor in this case. But is there a statutory remedy if somebody is aggrieved by an order of regularization?
What I have just understood from his submission, he is challenging that additional plan or that additional floor which was sanctioned. Now, my lord, the remedy is under section 397.
No, he is not challenging that. He is saying, even assuming that is a valid sanction, there is deviation from that. Now, that deviation was noticed by your officers, and then against payment of penalty of 14 lakh and odd,
The deviation is minor in nature, it can be regularized.
it has been regularized. He says this is not a minor regular deviation, so could not have been regularized.
At that stage, he ought to have taken up that point which was to be decided by the person concerned.
Could he have gone to, could he go to the tribunal? This is what I'm asking.
Yes, anyone who is aggrieved.
Anybody aggrieved can go.
One submission is,
This is what I'm asking. So,
Anyone who is aggrieved.
Your Lordship, I have a submission regarding this. Kindly come to page 128. The report has been filed in the month of December. And kindly come to page 129. Kindly see the date 18th of October 2022. I have filed this writ petition before the Honorable Court in the month of August. After such date, kindly see the last line of the page 128. Demand amount such and such was deposited and the sketch plan was issued to the applicant on 16th November 2022. After filing of the writ petition, having the knowledge, they did not appear before the writ court first. Then he come with this instruction that the deviation has been regularized.
what is wrong? Was there a restraint order by the court?
Your Lordship, regarding minor deviation, there is no such definition in the, and Your Lordship, if you may I show
Is
you,
your senior likely to come today? No.
I think Mr. Banerjee is,
We'll dispose it of. Go to the tribunal.
Your Lordship, then kindly heard Mr. Banerjee.
After half an hour, Mr. Das, no. Then you should have taken adjournment at the very beginning.
Your Lordship,
You should have taken adjournment at the very beginning. After addressing us for half an hour, we are not going to adjourn this.
then kindly,
You have submitted also. Previously, you have also submitted over this issue.
Issue.
Your Lordship, kindly keep it at top tomorrow. Kindly heard my learned.
We are allowing your prayer. That is consideration of your representation. So
Your Lordship,
there is no problem.
I have filed this writ petition before the learned single judge regarding non-consideration of my representation. But report has been filed. From the report, it has been clearly shown that deviation has been regularized, Your Lordship. And when it has been regularized, when the writ petition has already filed. After
person aggrieved by the order can
after that during pendency of the writ petition,
there is no injunction order.
at that point of time, the writ petition was moved and Honorable Single Judge directed to give another notice to the corporation.
This appeal is directed against a judgment and order dated January 11, 2023. Why did the question of locus standi arise? The learned single judge did not take that point.
Yes, Your Lordship, the learned they have also raised the point of locus standi before the learned single judge, but the learned single judge was satisfied regarding the locus standi.
There was there's no discussion at all.
No discussion has been.
কেন তুললো ওটার কথাটা উঠলো কোথেকে? কে জানে যাকে।
And after that,
January 11,
learned single judge
2023.
was pleased to direct the KMC to file report.
Whereby the writ petition of the appellant was disposed of by a learned single judge of this court. Paragraph: the appellant had approached the learned single judge with the grievance that the private respondent in the writ petition has made unauthorized construction and or construction in deviation from the sanction plan. Stop. The Kolkata Municipal Corporation filed a report before the learned single judge, wherefrom it appeared that the deviation that was detected has been regularized upon deposit of the requisite what do you call it, Mr. Mukherjee? The for regularizing penalty or what? Penalty. The requisite
Charges and penalty.
retention charges, retention charges. Payment of retention charges in the sum of approximately rupees 14.
In that Nirmal Kumar Das, as I have read that judgment, the Lordship has gone into the details in that. The regulation came in 2014.
Correct. 14.09 lakh. Stop. Accordingly, the learned judge disposed of the writ petition without passing any order. Paragraph: being aggrieved, the writ petitioner is before us by way of this appeal. Paragraph: although we have heard learned counsel for the appellant on the point of locus standi of the appellant to maintain the writ petition, since the impugned construction is in Howrah, is in Salt Lake,
Salt Lake
and the appellant is a resident of Howrah, we need not go into that question. Stop. Need not go into that question or express any opinion on that in the present case. Paragraph: we are told by learned advocate for the appellant that a representation
at page, Your Lordship, 113. 113 of the stay application
has dated June 25. Mr. Das, the problem is now that they have regularized, they will say nothing remains in your representation.
But I want
Therefore,
one provision from the
sir, that you go before the tribunal, you're not understanding.
regarding 100 and 400 and
My lord, I want to conclude one thing. My lord, the construction has been done, sanction plan has been granted, and my lord, completion certificate is also granted. My lord,
Very well. We are not interfering.
yes, my
madam.
lord. My lord, actually, the third party interest has been inserted this matter. So, my lord, there is no question of unauthorized construction and this
We are not
presentation.
deciding. Mr. You please take a decision on the representation. Reject it, do whatever you like. Reject it. We are not asking you to allow it. কি বললো? June 25, representative, comma 2022 has been made by the appellant to who should decide? Special officer building. You tell us, you are the corporation council. Huh? কিছু জানে না এসব আছে কি কি বললাম to various officers of the corporation including the executive engineer comma borrow dash Roman 3 comma KMC. Stop. Borrow 3 committee capital C, huh? KMC being the respondent number 6 herein. Stop. We direct the executive engineer to dispose of such representation by a reasoned order, comma, in accordance with law and the applicable rules and regulations, comma, within a period of 12 weeks from the date of receipt of a copy of this order, after affording opportunity of hearing to all concerned parties, including the present appellant and the private respondent. Stop. The order passed by the respondent number 6 shall be communicated to the parties within a week from the date of the order. Stop. That is all.
Learned order of the learned single judge. The order for the presentation.
From the date of receipt of a copy of this order, along with a copy of the representation.
Order of the learned single judge.
Naturally, this order will prevail.
As your lordship.
Best, no affidavit is called for it.
Affidavit has been filed, your lordship. Affidavit has been filed from the KMC also and private respondent also.
Oh, affidavits have been filed
Yes,
Yes,
your
my lord.
before us.
Yes, your
Yes, my lord.
Chalo, oটা লিখো না।
and reply has also been filed.
Application item number 1.
My lord, I'm appearing for the respondent plaintiff, my lord, in this matter, my lord. Mr. Ritrobato Mitra was the other side, my lord.
Yes, the judgment debtor,
Yes, judgment date.
applicant.
This is-
Application, my lord, under Order 9, Rule 13.
Yes, I remember. Ex parte decree,
Ex parte
you
decree.
say you have secured more than the decretal amount.
Well, there's one way of doing it is to, my lord, give your lordship the brief background, the factual background, and then take your lordship into, my lord, the grounds. But, my lord, that may not be relevant or necessary at this stage, only for the reason a service was affected. Order 9, Rule 13, lordship is aware. Sufficient cause and or insufficiency of service. Sufficient cause for not appearing on that particular day when the matter is taken up, or, my lord, alternatively, my lord, summons has not been served or not properly or adequately served. These are the two grounds. My lord.
That would also be a sufficient cause.
Yes, of course. But I'm saying summons served, but I couldn't appear. It can also be summons is served on me, but I could not appear. And, my lord, I have some sufficient cause to show your lordship that why I couldn't appear, and your lordship
Correct.
is
I
satisfied.
was sneezing all day.
Could be, my lord.
Correct.
Could be a sufficient cause. But, my lord, in this particular case, my lord, if I could show the negative, why would I not appear? Because, my lord, the summons had been served. It'll be
Harakiri.
It'll be a kindergarten exercise for me, my lord, to try and show that. I have taken the stand in my petition, my lord, that the person receiving it, one Debu Mondol, says it's 4 years, hence I can't remember. Already a harakiri stand taken, if you ask me. In the supplementary affidavit, I say, Debu Mondol was in any event not authorized by the company to take it, to receive on its behalf. Not an employee, hence, my lord, not authorized. So, my lord, my endeavor would be to show why I would not appear. If I had actually been served, my lord, service has to be, my lord, it has to be adequate. It's a suit after all. It's not an application. I must be given an opportunity to, my lord, come and place my case. Then, my lord, it's your lordship's discretion whether to believe me, disbelieve me, pass a decree, dismiss the suit. That's entire lordship's domain. But I cannot be, my lord, without, my lord, asked to suffer an order, a judgment, a decree, without, my lord, getting an opportunity to be heard. So, my lord, facts are like this. This company, the defendant, who's now the applicant before your
Do
lordship,
not think I'm rushing you. I'm not just assessing roughly how long you will take. Because Mr. Dhruvo Ghosh is waiting for his matter. If you take the entire day, we'll release him. That is why I'm asking.
But sometimes I rush myself and I finish quite early. So I don't want to get into that.
You will
But I think
argue
till 4 o'clock, my lord.
You will argue today? No. Why?
I'm led by Mr. Jishnu Chaudhary, my lord.
That is no reason for you not to argue today.
He has personally requested that he wants to argue this matter.
Very well.
I think till 4 o'clock, my lord, I can.
Till 4 o'clock, surely you'll,
Surely I'll take.
till 4 o'clock. You are for the contempt or? No. We'll take it up at 4 o'clock. Come back at 4 o'clock. Even if he doesn't finish, I'll stop him.
So, my lord, the defendant who is now the applicant before your lordship is, my lord, or was a family held company of the Patodias. Now, my lord, the plaintiff, which is also, my lord, a company, South Calcutta Diesels Private Limited, is also a company which, my lord, is controlled by a relative of, my lord, one of the warring Patodia brothers. There are 5 brothers. This is between 2 of them.
Yes.
So while, my lord, he is a part, my lord, of the defendant company, he shoots certain letters, communications, correspondence, sort of, my lord, admitting the claim. Let us, my lord, take my worst possible case. Let us take, my lord, there's an admission to that effect. I'll take it as bad as I can. And still, my lord, try and succeed. A winding up petition is filed for a claim of 10 lakhs. Now, my lord, the basis of this claim is certain orders were placed for me to supply certain, my lord, tools. So much I think is fairly indisputable. Let me don't jump up as a jack in the box. I'll place your case as well. Don't worry.
We can place at this.
Yes, yes.
Yes.
Now, my lord, they run a case, my defense, they run a case. Of course, when they put up, place an order on me, they give me some advance. I receive the advance, that order is cancelled. This happens, I think, twice. So a sum of rupees 10 lakhs is, my lord, the totality of the claim. Their case is, no, this is a loan. They say, this is a loan. If this is a loan, there is no way they could have proceeded with the suit in view of Section 13 of the West Bengal Money Lenders Act. That's their case, plaint case.
License.
They're not an NBFC. In the winding up petition, my lord, I offer a security for the entire amount. 2012, the winding up petition, my lord, is permanently stayed. On the ground, a rider has put, yes, I'm staying it permanently. However, you have to secure the entire principal amount. I secure the entire principal amount. The order is, if you secure, relegate it to suit. If they don't file the suit, you are entitled to ask for the money back. They file the suit. I think 6 weeks or 8 weeks, whatever the time is given, I'll show you the order. They file the suit. In 2012.
Makes me nostalgic. This makes me nostalgic.
Why?
16.
16, absolutely. But this is not one of those 16. I'll show you the order.
Yes.
So, my lord, I secure the amount. Entire amount. Suit is filed. My lord, if, now, what I was trying to say, that I'll try and prove the negative. If I contest the winding up, offer the security, get an order of permanent stay, why would I not, my lord, upon being sufficiently served, come and appear in the suit?
As I said, why would you commit suicide? The point is, Mr. Mitro, you think you have not been sufficiently served
That's, I
because Devu, who was in cahoots with your other side perhaps, took it, put it in his pocket, forgot about it, didn't tell you.
made to forget about it, whatever.
Now you are saying Devu was not authorized. How would the other side know, or the postal person know whether he was authorized or not?
Lordship is right on that. That's why
You
I
have to-
didn't
you have
place
to-
my case too high, my lord, because at the very outset I said that we've taken this stand in two separate pleadings in the same proceeding. Two separate stands have been taken. I'm not going to, my lord, press hard on that. But the point still remains, why would I, my lord, not come and appear when I have already contested a proceeding and obtained a stay? My lord, I don't know, I really don't know if the opposition which we had filed, my lord, in the winding up petition was before your lordship. While deciding the suit, since I was not there, it's not for me, my lord.
While deciding the suit,
Yes.
in all probability, no. Undefended suit, as you know what happens.
Yes, so they were duty bound. I don't know, but if they didn't, all the more reason, my lord, they were duty bound to say that, look, because in one place, to be fair, my lord, lordship has recorded the winding up petition.
Achha.
If your lordship kindly takes page 30 for a moment, the order, the judgment rather, which your lordship had passed on January 11, 2016.
Oh, Mr. Jishnu Chaudhuri has obtained the decree. So he wants to argue.
Is that a good ground, my lord? Since we have digressed, I'm sure you have that judge's day book. And there's one anecdote here. From Millard, a single judge, an appeal was preferred to the Court of Appeal. So the appeal got presided. I can't remember. One Lord, whatever, Millard, said some QC was addressing. Yes, Mr. So and so, tell me your grounds of appeal. So he said, my lord, this impugned order is passed by Mr. Justice so and so. And the judge replied, is that your best ground? So
yes.
So the lordship sees the order, my lord, the judgment. There is, my lord, a reference in the second page at page 31. Lordship has laid out the facts, and then, my lord, the third line from the top, the plaintiff instituted a petition for winding up of the defendant company under 434 of the Companies Act. By an order of February 6, 2012, this court relegated the plaintiff's claim to suit upon the plaintiff securing the entire principal sum of rupees 10 lakhs. Pursuant to such order, defendant has intimated to the plaintiff that the defendant has created a fixed deposit of 10 lakhs. Such and such, plaintiff has instituted the suit within a period of 6 weeks. It's granted by the order. So, my lord, lordship is made aware of, my lord, the winding up petition. But I can't find, my lord, if your lordship had occasion to consider my defense as laid bare, my lord, in the opposition filed before, my lord, the company court.
Honestly speaking, I wouldn't be able to recall.
My lord, it's impossible. It's impossible. It's 7 years. Well, the point I'm still trying to make is, why would I not appear?
Yes, yes, I have followed your point.
Then, my lord, kindly, my lord, again, my lord, in furtherance of, my lord, the case that I was making out, that supplies, kindly turn over the page to 32, my lord. Kindly have a look, my lord. This was one of the orders, my lord, which had been placed.
This argument of yours, why would I not appear?
Correct.
If I accept, then I will be accepting that you really did not have knowledge.
Yes,
of the service.
I'm very grateful.
That's
And
what you would argue, I
yes,
know.
my lord, I'm very grateful. Even bereft of the fact that a service has been made in proper form to the proper place, I'll show your lordship a decision. It's rather intriguing. And maybe it's time we corrected a few things. My lord, before I take your lordship to that, my lord, that order which your lordship referred to in your lordship's judgment at 321 is the winding up order, my lord. Rather, my lord, the order passed in the winding up petition. sorry.
Yes.
Since the company has agreed to secure the principal claim of the petitioner to the extent of 10 lakhs by making a deposit of such amount free from all lien and encumbrance with advocates representing the company, the petition is liable to be stayed. Company is permitted a fortnight's time to make the deposit of 10 lakhs with the advocates representing. Money will thereafter be invested, etc. Then, Millard, in the next page, Lordship will find the interest. If I don't pay, Millard, 10 lakhs would carry an interest at 10% per annum. Now, Millard, it is not in dispute, Millard, that I have deposited the entire amount. Millard, just a few dates before I proceed further. So, Millard, the order, the judgment and decree is of 11 January 2016 for 23 lakhs and odd.
Yes.
Millard, I'm sorry. A date before, 2 dates before that, Millard. The winding up order is of 6th of February 2012. The order directing security for staying of the winding up petition. Millard, we secure this amount on 5th of March 2012.
6th of March.
6th of March. 5th of March. 5th of March 2012. Millard, the suit is filed sometime in 2012 within that 6 weeks period. Decree is of 11 January 2016. Then, Millard, from 2012 till 2016, there's no communication. Till, Millard, till I'm served with a copy of an order passed in execution. So, Millard, this order is made on 6th of October 2016. And I come to know, my knowledge starts, Millard, from October 2016. That's when I get to know. Those are my pleadings, Millard, in paragraphs 11, 12, and 14. 11 and 12, I'm sorry. Now, Millard, once I come to know of it, I immediately come and file this application under Order 9, Rule 13. In the meantime, Millard, in the execution matter, that 10 lakh amount, which, Millard, I had deposited as security with interest, is withdrawn by my learned friends, by the plaintiff in execution. So about 16 lakhs and odd has been withdrawn for a decree of 23 lakhs and odd. 23, Millard, is inclusive of the interest which your lordship had granted in terms of the prayers in the plain. Then, Millard, in the execution itself, Millard, supplementary affidavit. Supplementary affidavit. Oh, I'm sorry, Millard, could I just draw your lordship's attention first to page 323 of the petition and then, Millard, to the supplementary affidavit. Lordship is at 323. So, Millard, the 10 lakhs is withdrawn September 2016, along with the interest. In terms of orders of court in execution. Then, Millard, kindly, Millard, take the Millard, there's a supplementary affidavit which has been filed by us. Sudhir Kumar Patodia.
Sudhir Kumar Patodia?
Yes, Millard. Now, Millard, kindly take page 234. It's an order, my lord, of November 23rd, 2016. For a decree, my lord, of $23 lakhs and odd. Kindly, my lord, see the opening line. The decree holder claims that the balance decretal debt is in excess of 26 lakhs. It is submitted on behalf of the judgment debtor that the principal sum claimed has already been paid, and the judgment debtor has applied for setting aside the ex parte decree. It also appears that the relevant application for setting aside the ex parte decree is fixed for to be heard on such and such. Since the amount due under the decree is said to be in excess of rupees 26 lakhs, the judgment debtor is directed to deposit a sum of rupees 20 lakhs with the registrar original side within a fortnight from date, whereupon the registrar original side will invest such amount by way of a short-term fixed deposit with any nationalized bank, etc. Then, let this matter appear on 7th December 2016. In the event the deposit has been made, the judgment debtor will be afforded some time to have its relevant application for setting aside the ex parte decree heard, decided. If the deposit is not made, no impediment in proceeding. So, my lord, for a decree of 23 lakhs, I am out of pocket by 20, which became 28 with interest, which they have taken in the execution proceedings now, plus that 16. So 28 plus 16, they have already taken for a decree of 23 lakhs, where the principal, my lord, was of 10 lakhs. My lord, kindly weigh the equities once.
But the problem is that the interest is probably still running.
At 18%, ex parte, my lord. And my lord, why would, with all due respect, my lord, why would the defendant be made liable to pay interest once the deposit is made? Deposit has been made immediately, 10 lakhs, then 20 lakhs. They are enjoying the interest once, second time on the 20 lakhs, and again the interest has to be paid. My lord, forget commercial rate of interest. This sort of profit, even the best investment can't get you.
This is a personal fight. We can all understand. It's a fight of ego, whatever it is. Friendly neighbor.
And no, my lord, and there's a partition suit pending between the 5 brothers, hotly contested.
Have you ever tried to settle?
Many
mediation?
Times, many times.
You've tried mediation?
No, not no. No, mediation.
No, professional mediation, not sitting with somebody.
No. We tried with
not a common friend or something.
No, not common friend, a senior person from the library.
Actual mediation.
Mr. Kapoor was the mediator. Didn't work out.
With great respect, Mr. Kapoor is not a trained mediator.
I accept that. I accept that.
But maybe even more effective.
Sometimes he's very effective. Very, very effective. So, my lord, I have, my lord, paid off this amount of money. And still, my lord, this is what's, my lord, bothering me the most. I still won't be given an opportunity to contest the suit. I'm a very bad person. I had notice, I had knowledge, all sufficient. I didn't appear. But here I am. I've paid the entire decretal amount and more. And I still won't get a chance to say that, hear me out. Lord, with all due respect. For 10 lakhs, they've taken 45.
If you don't succeed on sufficient cause,
No, I'll come to that. I'll come to that. My lord, there's a third limb. There's a third limb. My lord, the third limb is this. Like my lordship is aware, in a Order 12 Rule 6 or even a Chapter 13A, suppose you don't find a triable issue, do you still not have the powers, my lord, to put the defendant on terms and ask him to file a written statement? Of course you do. McCallick is very clear and has been consistent, well, starting from Karunamoyi Dashi, why McCallick? And starting from there, right down till 2018-19, Justice Nariman. Even if no defense, no tribal issue is found, even then the court can put you to terms, secure the money, and yes, file your.
why should the court do that? Why should the court do that? 13A, for example,
Yes.
meant so that a recalcitrant, clever defendant cannot drag on a suit for years together.
Correct.
Who actually has no trial
Correct.
issue.
But I'm saying, my lord, the court has the power.
Yes.
Court has the power. Similarly, my lord, in a Order 9, Rule 13, I have, my lord, come to court. I have secured the entire decretal amount. Would I not, my lord, be given an opportunity to place my defense?
Here you say you have not only secured, they have received.
More. Yes, they've taken it. That's an admitted possession. First 16 lakhs and odd, then my lord, 28. They'll be able to say the exact amount. 28 lakhs and odd, they've taken. So much is not in dispute. So now, my lord, if your lordship kindly takes these are, my lord, I think the sum and substance of the facts.
It's rather looks like a Bible.
Yes. Well, for us, it's almost the Bible.
CPC.
It's almost the Bible for us. So, but it's very handy.
CPC? এই পুরনো ব্রিজগুলো কাগজগুলো না কি নাম ছাড়তে এগিয়ে সব পোকা বেরোচ্ছে এর মধ্যে এবার এখানে একটাকে আমি ক্যারাম খেলে কোথায় ফেললাম জানি না এই তো না এটা সিআরপিসি I mentioned the Bible and there is JC.
But if you kindly take, my lord, Order 9, Rule 13 once, my lord. In lordship has it?
Yes.
In any case in which a decree is passed ex parte against a defendant, he may apply to the court by which the decree was passed for an order to set it aside, and if he satisfies the court that the summons was not duly served, that's one. Second, or that when the suit was called on for hearing, the court shall make or that when he was prevented by any sufficient cause from appearing when the suit was called on for hearing, the court shall make an order setting aside the decree as against him upon such terms as to costs, payment into court or otherwise as it thinks fit, and shall appoint a day for proceeding with the suit, provided that where the decree is of such nature that it cannot be set aside, this is not relevant for us. Now, my lord, provided further that no court shall set aside a decree passed ex parte merely on the ground that there has been an irregularity in the service of summons if it is satisfied that the defendant had notice. This is very important because I'll make my submissions on this. Notice of the date of hearing and had sufficient time to appear and answer the plaintiff's claim. So, my lord, even if the second proviso says, even if the summons is served, summons is not served, but you had notice. And I'll show your lordship. I'll just make my submissions on that. So, my lord, these are, my lord, the grounds, as I said, my lord, when I started, that these are the two principal grounds, my lord, on which, my lord, the Order 9 Rule 13 petition is made. Came across something very interesting regarding the second proviso. My lord, if you kindly take, my lord, Appendix B of the code. B for Bombay.
Form number?
My lord, form. My lord, one should be what should apply to us because it's for disposal, summons for disposal of the suit. Now, lordship has seen the summons.
One.
Yes. Form process number 1.
Yes.
It's a regular summons, my lord. Except, my lord, I just want to draw your lordship's attention to there's a particular day, year, and time which has to be pleaded, or rather mentioned.
Yes.
So, I have to be told when the suit will be taken up, the day and the time. Could be 10:30 onwards. I'll show your lordship something very interesting. This is the CPC, my lord.
Yes. There is an old Calcutta decision.
I'll show your lordship. I'm coming to that. I'm coming to that. I was hoping, my lord, your lordship would kindly have a look, my lord, at the original side rules.
In the event Mr. Dhruva Ghosh comes back, then please stop at 4.
I will, since I've said so, but I like the idea, your lordship.
See?
All you know, my lord, he is left.
Chapter?
My lord, if you kindly take, my lord, Form 2. This is, I'm sorry. It's Appendix B again, Form 2. Appendix B, Form 2. Lordship has that?
Yes.
My lord, strangely, there is no provision for date and time. It's a departure from the form provided in the CPC. And my lord, again, even more strangely, kindly have a look at Form 1. These are for summons in chambers.
Mr. Mitro, what the CPC, that form provided was to appear at a hearing.
No, that's the summons.
Summons, yes.
For
this
hearing.
one,
This is
one
also, my lord, for,
entering appearance.
well, I'll show you a Supreme Court which deals with this as late as 2018. My lord, it's rather strange. If you see, my lord, Form 1, form for summons of an order in chambers, it gives, my lord, the same provisions of date and time.
Form number 1
Yes, my lord.
refers to Chapter 6, Rule 3. What is that? Chamber
Chapter
business.
6. Yes.
Chapter 6, Rule 3.
Chapter 6, Rule 3.
Chapter 6, is it? Yes, Chapter 6.
Chamber.
Now, what is Rule 3?
Mode of process.
Mode of proceeding in chambers.
And it gives, my lord, the.
Has to give the date. Has to give a date.
My lord, insofar as the summons is concerned,
that is for appearance in court.
Doesn't give, my lord, the. My lord, if that is the case, my lord, there is another provision which says that, my lord, the defendants have to be put on notice if they don't appear. My lord, they have to be put on notice if they don't appear. And strangely, my lord, I found a Supreme Court dealing with this discrepancy. So, my lord, that's more or less, my lord. Next, my lord, I'll just take your lordship through the decisions, my lord, of the Supreme Court. But this is, my lord, what has happened so far.
Mr. Mitra, please also place your application. What has been pleaded? Because I remember once Mr. Jishnu Chaudhary had argued, hey, have you been in this matter from the very beginning? No.
When the clients couldn't afford, my lord.
This matter had been argued long time back, many moons ago, I think. Anil Kumar Patodia is the main litigant. He has colluded with the plaintiff company. These are the submissions made on your client's behalf. Then sufficient cause, paragraphs 12 to 15 of the petition.
That's what I was, my lord. I just referred 12 to 14, I said.
Collusion between Mr. Todi and Anil Patodia, yes. Clear?
They are the brother-in-laws. I've pleaded that in the petition as well.
Right. Now, the plaintiff argued, possibly Mr. Jishnu Chaudhary, I can't remember, no case made out in the petition. You can't amplify the original case by filing supplementary affidavit. No inconsistent case can be run. And several decisions he had cited.
Oh, decisions are here, actually. Decisions are here.
I'll cite a new set of judgments now.
You had cited 2003-4 Company Law Journal.
Yes, that is that you can't amplify your case by a supplementary
April
affidavit.
3, you had cited 2015 SCC Online Delhi 8131. Then AIR 40 Calcutta 95 on retraction. Then 2017 1 CLJ 561 service at registered office was cited.
I'm very grateful, my lord.
Take these 4 decisions at least. এই চারটে দাও ওকে এই
তোমার কাছ থেকে তো লাভ হচ্ছে না
কথাটা দাও
আমাকে ডিসক্লোজ করছো না
দাও এই চারটে ডিসিশন নিয়ে নিকো
লিখে নাও
লিখে নি এটা দেবে না পেন নাও তোমার থেকে
I have to give him my note, you have to give him your pen. Somebody give him a piece of paper.
No, I have to follow. No, note to I have to, my lord. 2000.
The second time I'm seeing a judge's note of our submissions. First time was I had argued exhaustively, I think over 10 days before Justice Sanjeev Banerjee. And I said in other matters, I know you don't take a notes of argument. But in this matter, we've argued so much. So I prepared a short note, just point form. He said, you come at 1:15. He gave his notes and said, compare. If I have missed, then you write down in pencil. Nothing missed. Not as of the present, my lord. Apart from this, my only argument is that there is a complete inconsistency, which I will.
Complete?
Inconsistency.
I started with that when you were not there. I've already told the judge.
না ঠিক আছে হয়ে গেল আজকের মতো শারদ ধ্রুব এসে গেছে
Started with the inconsistency.
4th October ওই actually 4th October can't be before that. Are you keeping the tradition alive?
Yes, yes.
I was just telling him.
Mr. Learned advocate for the applicant oblique judgment debtor resumes আগের অর্ডারটা কি আছে আগের দিনের অর্ডারটা দাও ফাইলটা দাও
Almond my lord, and Lordship had been pleased to protect us, my lord.
That protection continues. It's from us.
It is understood since we are hearing this, nothing further in the execution.
As I said, if Mr. Chaudhary is there, I'm safe.
Yes.
But especially Mr. Ghosh, he's not here.
Yes, আর কিছু নেই
Yes, this is now coming in November. We have gone and agreed to an adjournment. হ্যাঁ কুলদীপ ছিল তো কাছামাছি মুখ করে দাঁড়িয়ে আছিস কেন কিচ্ছু মনে নেই তো
Yes, resumes his argument but does not conclude. Paragraph lists the matter once again on October 4, 2023, for further hearing. I had recorded in my last order.
Milord, after that, Milord, matter appeared in the executing court. We appeared, and now it's due to appear in the monthly list of November. So there's nothing, and we will ensure it's not taken up.
Grateful, my lord.
After a long time, I'm hearing a real original side matter. Because the original side matters we have are again all repetitions.
Yes, now. Good.
But now, Milord, this is, in fact, I said this to the learned interlocutory judge today. I did a new motion from 11 to 1 today. I said that your lordship will not, Milord, appreciate the pleasure I have of being in the interlocutory court for 2 hours. Now everything is going to NCLT. New suits not being filed, those motions, interlocutory applications, new motions.
Commercial suits,
Commercial suits are, my lord, the problem now with commercial suits.
section 12, no.
So we have devised methods of going elsewhere and going elsewhere.
There's no original side practice. The practice, Lord, we had seen our seniors have, and we also for the initial years
that we have to intimate them what are the dues as on date for running the shop, because they were to pay as per the order of that 500 rupees per day for running the shop, which is our 1/3 share. So Lordship passed an order that we have to intimate them, let a copy of the calculation sheet be served, and learned advocate for the respondent, that is my learned friend, who is requested to take a look into the matter and ensure that if anything has fallen due as claimed, such dues have to be paid off by the next date. So we have served them. Your Lordship, this is
Who
the
is
letter
appearing, who is appearing for the contempt?
learned friend.
For the complaint.
Yes,
We have
Mr. Mal.
intimated them as on date, the dues are 4,78,000 till date, 20th September
Sir, it-
2023. They have to pay this money.
My lord, it's been broken down into two components, broad components. One is till 2017, and my lord, the figures thereafter.
No, nothing is due from 17. It's
But
due
till
from
till 17.
18 November 2021.
No, no.
That is the money which is due. That is the calculation. I think he's not been properly instructed. Yes, this is the calculation. If your Lordship kindly takes the supplementary affidavit, which we have also served, we have given the detailed list and the calculation from 18 November. Till 17 November, till 16 November, they are paid. After that, they are not paying. My learned friend wants to pay me more, I have no difficulty. He's saying from 2017 it is due.
My lord, I'll just.
that
Yes, paid till.
They have paid till 16th of November 2021.
Calculation. I'll just confirm.
So calculating that from 17, the due as on date is 4,78,000.
Lord, I've spoken to my client. The
Hmm?
business, I've spoken to my client.
Yes.
I've asked him, my lord, the
Yes.
order is absolute. There's no
Yes.
discrepancy on that. No, এটা payment টা
So
যেটা
when will you pay? Do you want installment? Tell me.
At this point of time, my lord, we are trying to, my lord, figure out an ad hoc payment, something that we are trying to arrange, that we can make over maybe by next week.
Your Lordship, this same
By next-
submission was made.
My lord, the problem is, my lord, I have
No, but
asked him
Look,
once
Mr.
and
Mal,
for all.
Mr.
My
Mal,
lord.
please, even on instruction, don't be vague. Tell us a sum of how much?
50,000, my lord. 50,000.
Not acceptable.
50,000 for
Not
like.
acceptable.
My lord, 50,000, my lord. I'll try to make over the rest in installments. I'll confer. What is the exact period of installments? My lord, I asked him to shut shop.
Mr. Mal, this is a contempt application.
Lord, I understand. And I've asked him to shut shop.
This
for
is
good.
an indulgence that
My lord,
he's
may-
getting from court.
I understand, my lord. My lord, may I intimate this, my lord? 2020, post 2020, there were a lot of difficulties. Now, my lord, for a change, I went through the original order which was passed by my lord Justice Bhattacharjee. 500 rupees to be paid by the plaintiff by the defendant number 3 and 4. This was subject to the final decision which may be taken in the suit.
I am listing this matter on the 4th of October when I'll sit again singly.
I'll be very grateful, my lord.
And
Some ad hoc
I'll
payment.
be expecting that at least 50% of the amount due should be paid by that date. Don't look at him. He will say not possible, can't do.
Your
I'll
Lordship,
tell you,
the
Lordship,
premise
my
on
lord.
which this order was passed, they were running the shop. They were not paying us our 1/3 share. We made an application for closing down the business.
My lord,
Oth-
he
said
wants
that
to
you
sell
pay
off the,
rupees
my lord,
500 per day.
I'll tell you,
Otherwise,
my lord, I'll tell your lordship this, my lord. They are very, my learned senior friend, my lord, is very interested
I
in
am
selling
not
off the
making-
property.
I am
My lord, let the properties be sold off. Let it be adjusted from my share. Because I actually do not have
That
any
is
money.
contempt.
I actually do not have any money.
Submission
No, because I
denied.
cannot. Your lordship,
Contempt of this order.
if I'm in contempt, my lord, and if I do not have the monies, because your lordship will have
Go
to
to
appreciate,
prison. Your
no.
properties will be attached.
and it doesn't matter because I have nothing.
Doesn't matter what.
He wants to sell it off. That is
Then
the
if he
final due.
cannot pay, let his share be attached in our favor. Let
Not in his favor.
1/3 share
Because
be given
today
to us.
I cannot. I am not
Yes,
going to
that is
alienate.
the
I am not going to alienate my
Consequences of
shares.
a contempt
very
application.
well, very well. Come back on the 4th.
Properties have to be attached, or you say you are sent to civil prison. You want that?
Mr. Mal, from a learned advocate appearing for the alleged contemnor, says that he has instructions that within the next 2 weeks, an ad hoc payment will be made by the alleged contemnor towards the dues of the petitioner. Stop. Paragraph from the calculation sheet, as recorded. Today the due is how much?
4,70,000.
It was 68 on the last date.
Yes, your lordship, that was on 30th of August. Now 20 days. Till 10th of September, we have calculated as 4,72,000.
This is on account of sale of sweets.
Sale of sweets, our share which they were to pay rupees 500 per
How
day.
do you know how much they have sold?
That is the order of the bench, division bench. So it says that since I made an application on closing down their business, this is a profitable running
How
shop.
do you find out how much they have sold on a particular day?
That was the order of the division bench.
What order?
29th
has
of
come down from
29th of
12.
November 2010.
It has
Your
come
lordship,
down.
we have made this as a part of our application, page 23 is the order.
To what effect? The order is to what effect?
Yes, we made an application. I said that you pay me my share because you're running the business without paying my share. I made an application that either you pay my share or you close down the business. Division bench says that it's no point of closing down the business. You run the shop, but you pay our share till the pendency of the suit.
Till the
That is
pendency of
rupees
the suit.
500 per day.
500 per day.
Per day.
The division bench said that.
Yes.
My lord, till the pendency of the suit.
Yes, the suit is pending.
There's no
It's pending.
Suit is pending.
There's been a sale order. He can very,
Actually, the amount should have been
want
much
to,
more
my
as
lord,
on date.
Mr. Mal, so long as division bench order is in force, I can't touch it.
my lord, I understand. My lord, 12 employees have come down to one. It might look very happy at the picture, but it's not at all.
Anyway,
Your
towards the
lord-
dues of the petitioner. Stop.
2015 order. 8
List this matter again on October 4, 2023. Stop. It is expected that by that date, comma, by that date, at least half of the amount due would have been paid by the alleged contender to the petitioner.
Your lordship, may I only propose one thing? I believe there is some the discrepancy with regard to the instruction which my learned friend is getting from his client. If he's allowed, if he's directed to be present, he can directly give instructions as to what is the actual amount due and
Present
how
in
much he
court.
can pay.
My lord, it's
If
with us.
Doctor, if your lordship can, he directs, my client is already there. If he comes,
Oh, he's your client. I was thinking he's
No, it's not possible. He doesn't have. It's beg borrow steal situation for my client. Absolutely, because
ask him to be here.
I'll ask him.
even present.
Acha, Mr. Banerjee, Mr. Mal, this is between family members.
Correct.
It's between family members, my lord.
No chance of a settlement.
They don't want
Yeah,
to.
tried.
Two defendants, my lord.
Who has not?
My lord.
Second.
Acha, no, Mr. Ghosh is
Have you approached us?
Mr. Ghosh is waiting you come back on the 4th. Come back.
His client be there. He will not pay our share and he wants a settlement. Let him propose. Let him propose a settlement. We'll see to that. Let him approach. He'll not.
Commercial matters, settlement is possible. Family members,
Very difficult.
settlement.
Acrimonious. It has become very acrimonious.
Come back on the
I'll-
4th of
I'll-
October.
Number 3.
Rule was served.
No,
No,
rule
rule-
hasn't been issued yet.
Rule has not been issued.
The petition was to be served. It had come back on the affidavit of service. But the gentleman was here, I'm told. My instructions were. And someone was appearing for. The order, page 15 of the petition, Manoj. Page 15 of the. The earlier order of December 22 is at page 23, but this is the order.
Prairie usual injunction must be.
Yes, and nobody was appearing, then we served. Now, thereafter, well, that was the injunction application. Thereafter, if my lord comes to page 43, the English translation, they have sold one of the properties, which is in the affidavit of assets. The injunction was on this property. Page 44. When's the date? In July 7th, 23 is the certificate was issued.
Yes, you have served. Raise the affidavit of service.
Yes,
No, I
And
don't.
on page
You
nine,
are satisfied, Mr. Ghosh? Mr. Mondal, you are satisfied? Service has been effected.
yes, he was here.
He
my
was sitting here.
instructions were that-
He was waiting here.
very- Page, page 19 is the affidavit of assets which mentions this particular property.
No, no, I'm not on that. I'm on service now.
Yes.
This says item delivered to sender.
This has come back with intimation sent. That means they were told that it's come. Then addressee absent, intimation sent. And same, first day addressee absent, second day intimation sent.
Yes,
That
but
is-
that is not actual service.
They serve, and then if you're not at home, they leave that intimation and they have to come to collect it. Then they don't collect it, then it's returned.
Yes, if they don't collect it, they
Because
wouldn't
the
know.
address is, it's been at the right address, the addressee was absent. It's not
Mr.
that,
Ghosh, they wouldn't know that this is a notice from the court or.
no,
in-
this is the petition. This is the petition.
Yes, they wouldn't know that. The postman wouldn't say what is there.
No.
They would say
but-
there's a
but the-
parcel,
Yes,
we came to deliver, come and collect it.
yes, and they haven't come.
May not be that would that be good service.
It's at the right address, it was served to them, they did not accept it. If it had been refused, it's the same thing.
Not the same thing as refuse. No, no.
Then even, well, as far as the
Since this is contempt, we have to be very, very careful. It's a quasi-criminal
issue a show
jurisdiction.
cause, but it's on the face of it that we have given the registered document that they have dealt with it in July and the order was in January.
Why can't you have it pasted on the walls of their houses?
We did that for the injunction application.
Do the same thing. Do the same thing, then there'll be no controversy.
If my lord gives the direction for them to show cause, not the rule, we'll serve that order along with the petition.
Again, how will you serve? The same thing. The same problem
Then
will arise.
We'll do this. Last time we took a photograph, it was pasted on the wall. They live in the same house.
Rather than showing cause,
No, too expensive.
I'll give a direction for affidavits. Let
Yes,
them
to
explain.
show cause, to show cause. by
Basically,
the-
a show cause
Yes.
to file affidavit in response to your allegations.
And to reserve the petition on them.
Yes. So you now this time do it personally.
This was gone very well.
Issue.
Personal service will be issued.
From the affidavit of service filed in court today, it does not appear that proper service has been effected. Stop. The envelopes could not be delivered to the addressees. Stop. Paragraph. Let service of the petition along with the present order be effected personally on the alleged contemnors. Stop. If the alleged contemnors refuse to accept or cannot be found, comma, service may be effected by pasting copy of the order on the outer walls of the respective houses of the alleged contemnors. Paragraph, the alleged contemnors shall file individual affidavits showing cause as to why they should not be committed for contempt of court for having willfully violated the injunction order dated
January 2nd, 2023.
January 2, 2023. Stop. Such affidavits will be filed. We'll keep it after the pujas. Before that, no. 4th October, there's no time. I'll be sitting on 4th October.
We were hoping that at least this limitation point, I can remind your lord, that's the next matter.
No, so you do that on the next day, you do that limitation point so that I may be able to deliver judgment before the by কোর্ট খুলছে কবে?
ওটাকে রেকর্ড করবো যে ছিল
November 17. November 17.
দেখা যাবে তো
দেখা যাবে তো।
Hmm?
Because they are পেছনে বলছিল যে
Stop.
My lord, yeah. Only can it be recorded on instructions, my lord, that the contemner number 2 was present in court. It will be evident now if I rewind this, we will be able to identify him if he denies it.
I can record Mr. Mondol's statement, but will that be appropriate? Just think about it.
No, because he
Because
was,
I don't know him.
no, it's our contention. Then, my lord, we will see it in the YouTube. We'll take a screenshot. He must have been here if he was. I don't know him
Do whatever you like.
because I just noticed that it's all being recorded
Do whatever you like.
unless it's been put off.
List the matter once again on আবার একটা single date দিয়ে দাও। Affidavit to 17th November.
Well, let the affidavits be complete this
Do
side.
you want to file a reply?
If
Okay, reply there to if any, be filed by November 23.
well, let the affidavits be complete before the holidays, and your lordship keeps it as soon as the two.
Mr. Ghosh, I can give you dates, but then you'll come back and say again, we couldn't serve.
No, we will have to serve, and this can be recorded. We'll go and check.
Check, do whatever you like. বলো তাহলে এটা করো। Opposition টা এগিয়ে আনো।
There should be some pressure on them. They're
Opposition টা
selling
বলো।
away all the properties. It's not our fault. my lord.
By October 6. Reply there to if any,
By
we
18th.
October 13. তাহলে শোনো ইয়ে অক্টোবর 17 একটা দিয়ে দাও আমার ডেট দিয়ে দাও দেখে নাও ফাঁকা আছে কিনা
প্যারাগ্রাফ কিন্তু কোড দাও দিন আর ওখানে ডেটটা দেখো
দিয়ে দাও 17th October.
But as far as the suit is concerned, I just had to say 2 lines.
Yes, you can finish it off today itself. Right?
Yes. If my lord sees we had filed a list of, I'll just, if your lordship notes it in our notes for arguments, it's in paragraph 22.
আরেকটা আছে আমার কাছে
We have another copy. But paragraphs 20 to 24, we have dealt with it. I just want to show my lord that judgment once again to refresh my lord's memory. This is the SCC online version. We have quoted the AIR page number was wrong. But the page number in paragraph 24, it should be 3328. 2019.
Yeah. 3328.
Yes, it should be 28. I'm sorry, Manoj. In our note, earlier note also. But the equivalent citation in SCC, my lord, is 2020, 12 SCC, page 480. I have handed over another copy. 2020, 12 SCC, 480.
into 18 this without
And paragraph 15 to 18. I'm relying on, I'm just reading out paragraph 18 because it sums it up. My lord. 15 to 18, 15 to 17, they've dealt with those earlier two judgments of the Supreme Court, which says that Article 138 will apply.
37, yes.
137 will apply. So it says that it will apply when the right accrues, not when the right accrues for the first time. So those first two decisions that we have given is distinction between first time and when a right accrues. But if in this judgment, my lord, if my lord sees paragraph 18, it deals with that Madras case also. Then applying the law laid down by this court in the aforesaid decisions and observations made herein above, the submission of the appellants that the probate case for such and such read with is barred by limitation cannot be accepted. At this stage, it is required to be noted that even in the plaint, it is specifically pleaded that after the passing away of the father of the parties, the appellant started intermeddling with the properties bequeathed to R2, which was situated in Delhi and therefore left with no option, he was compelled to apply for letters of administration. Therefore, even as per the pleadings in the application, the cause of action started from the date on which the appellant started intermeddling with the properties bequeathed to the respondent number 2 after the passing away of his father in 2000. Therefore, in the facts and circumstances, both the learned single judge and division bench have rightly refused to reject the application in exercise of the power. In our case, 2001, they filed. The gentleman died in 1996. There was no need for me to get the probate because there was no dispute. In fact, one of the properties in Kanpur was also dealt with under the will. I had knowledge of the will. It's not from knowledge of the will or death. The limitation doesn't start. The limitation starts when the need for probate is required. So there.
I followed. How has this court dealt with the judgment of the Supreme Court?
Yes.
Where it was held that 137.
Paragraph 15 onwards. That judgment also, it's really the 2009, there's a 2008 and it's cut paste in 2009. And that portion which has been cut paste, the last line which says so and so, this subsection will apply and this won't, that is not there. So all of it will apply. But I don't want to get into that. My lord, this judgment, I think, satisfies that point. So 15. Now the question which may arise for consideration would be whether the application for probate or letters of administration, the period of limitation would begin to run from which date. While considering the issue involved, the decision in Kunwarjit Singh Khandar, that is the 2008 decision, is required to be referred to and considered. In the decision, in the said decision, the court considered the decision of the Bombay High Court in Vasudev Daulatram Sadarangani, as well as the decision of the Madras High Court in Krishna Swami. This is the one my lord referred to that day. In the said decision, this court referred to and considered paragraph 24 of the Madras High Court in Krishna Swami, which read as under. This I had submitted, this was the law that prevailed till this came in. So, but it still doesn't make a difference because when your right can accrue several times, it's not so. So I'm just for the sake of reading this for my own, since this was the view our court also used to hold. In a proceeding, or in other words, in an application filed for grant of probate or letters of administration, no right is asserted or claimed by the applicant. The applicant only seeks recognition of the court to perform a duty. Probate or letters of administration issued by the competent court is conclusive proof of the legal character throughout the world. An assessment of the relevant provisions of the Succession Act does not convey a meaning that by proceedings filed for grant of probate or letters of administration, no rights of the applicants are settled or secured in the legal sense. The author of the testament has cast a duty with regard to the administration of his estate, and the applicant for probate or letters of administration only seeks permission of the court to perform the duty. There is only a seeking of recognition from the court to perform the duty, and this duty is only moral and not legal. There is no law which compels the applicant or letters of administration. With a view to discharge the moral duty, the applicant seeks recognition from the court to perform the duty. It will be legitimate to conclude that the proceedings filed for grant of probate or letters of administration is not an action in law. Hence, it is very difficult to, and it will not be in order to construe proceedings for grant of probate and letters of administration as applications within the meaning of 137. Then, this court approved the observations made in paragraph 24 of the High Court in Krishna Swami, insofar as the nature of the petition for grant of probate is concerned. However, this court did not agree with the finding that the application for probate is not covered by Article 137. In the aforesaid decision, this court also considered and referred to paragraph 16 of the decision of the Bombay High Court, which reads as follows. Then, my lord, those A, B, C, D, E, F up to G is given. And at the bottom, in the 2008, this is there. In the 2009 decision, it's not there. This court did not agree with or approve conclusion B. So he says that why he rejected this conclusion B was the assumption under Article 137 was the right to apply accrues on the date of death is unwarranted. This proposition was rejected. He rejected Mr. If my lord sees the top, it's a bit confusing. I summarize my conclusions. So he says that it is unwarranted. But then at the bottom, he says that he does not agree with this. However, conclusion C, reproduced above, approved conclusion C, which says such an application is for court's permission to perform a legal duty. Then, therefore, considering the law laid down by this court in Kunvarjit Singh Khandapur, it can be said in a proceeding, or in other words, an application for grant, no right is asserted by the claimant, by the applicant. The applicant only seeks recognition of the court to perform a duty. The probate is issued by a competent court is conclusive of the legal character that the proceedings filed for probate is not an action in law, but it is an action in rem. It is held in Kunvarjit. Then it's again set out, my lord. Therefore, even if a will is probated by court mentioned under section 228, the right to get letters of administration is a continuous right and can be exercised at any time as long as the right to do so survives and the object of the trust exists or any part of the trust. It should be objects of the will, but if the will, if created, remains to be executed. But the provision 137 says, that is my main point, irrespective of the conclusions of there, that the provision says when the right accrues. And in this judgment in paragraph 8, intermeddling with the estate is when your right accrues. When for the first time, so in this case, my lord, your lordship will see the facts. In 2001, they filed a partition suit for ancestral properties. So and I filed in 2003.
The need accrues. The need arises.
The need arises.
Intermeddling,
yes.
The need arises.
No, the language in 137 is when the right accrues. So it's when the need arises. Otherwise, a person who's made the will, anyway, he has no control over it. If I'm given I'm made the executor and I sit on it and I don't do it for whatever reason, even the beneficiaries his will is not being probated. It's not a question of adversarial proceedings.
Very well.
In that.
That is all.
Yes. Even 137 ought not apply, but since Supreme Court has said it, we have to find a way to read it harmoniously with what is the nature of a will.
Never applied.
No, it never applied.
Never applied.
But now it's there.
That's what
That electricity matter, there was a statement in 1977 that there should be a period of limitation for every application made to court. And previously it was the delay would be a suspicious circumstance. It could play against you.
Hearing is concluded. Judgment is reserved. File is taken. Thank you.
Great.